Thank you, sir. And good morning, ladies and gentlemen. Welcome back. As you know, we've swapped out court reporters this morning, so we apologize for the delay, but I think we are ready to go. And thank you, Madam Court Reporter, for making yourself available on short notice. Let's see, a couple housekeeping matters. I understand that Mr. Cox is here today representing the state of North Carolina. Is that correct?
Yes, sir.
All right, we'll note that for the record. One other matter. I can tell you that the documents, public documents that are available on the AOC website have been well received. We've received comments about how grateful members of the public are to be able to access those documents. There's one document that we still had some discussion about, and we just wanted to confirm with all parties that that document was not something that there was any objection being placed on the website. It's the legislative defendant's reply in support of the motion to produce documents from the North Carolina Democratic Party contained some excerpts from a sealed portion of a deposition that I think has largely been talked about, but we're happy to either continue to keep it sealed or publish the document. Mr.
It may be published, Your Honor.
I'm sorry?
It can be published.
It can be. Thank you very much, Mr. Speaks. All right. So we'll, and I think everyone else has chimed in on that via email, so we'll let the AOC know that that document's available. All right. With that being said, I believe we're ready to proceed with Dr. Chen and further direct examination through Mr. Jacobson.
Good morning, Dr. Chen.
Good morning, sir.
Your Honors, as I briefly started to explain yesterday at the close of the day, just to give a little bit of context for the next 4 exhibits, which we had emailed to the court on Monday night. As we explained in our emergency motion to compel, Dr. Chen had previously done some analysis of his own computer simulated maps using the estimates of legislative defendants expert, Dr. Lewis, the minimum BVAP needed that for African American preferred candidates to win. Obviously, this court granted our emergency motion to compel. We received the new information from legislative defendants Monday morning, just shy of 10 a.m. Dr. Chen then immediately got to work just updating his analysis based on those new numbers. As soon as they were ready, we emailed them to the court. So these new exhibits are just it's the exact same thing Dr. Chen did in his report. It's just updating it for Dr. Lewis's new numbers.
And Your Honor, not wishing to interrupt counsel's examination, but we have a standing objection to this testimony about the updated Lewis report and the charts that Dr. Chen has made based upon the updated report on the grounds that there's no longer anything to rebut.
All right. Your objection is noted. I think we ruled on that objection yesterday, so the standing objection is allowed and it's overruled.
Thank you, Your Honor.
Thank you.
Your Honor, may I approach to hand you the exhibits?
Yes.
We could pull up Plaintiff's Exhibit 773. Dr. Chen, what does this exhibit show?
This is Dr. Lewis's amended version of his Table 4, which I received this Monday.
And what does Dr. Lewis estimate in the far right column of this table?
The far right column is Dr. Lewis's estimate of the African American percent of the citizen voting age population that would be required for the African American preferred candidate to win in a hypothetical 2016 general election contest in these various counties and county groupings that we see listed here on the first column of this table.
And would that include a hypothetical state house or state senate election in these particular county groupings?
Yes, it would.
Your Honor, I'm sorry, just to clarify, I know this is going to be overruled, but I would also just like to state an objection to Exhibit 773 on the grounds of hearsay, since Dr. Lewis is not here to explain what it is, and I understand the court's going to overrule it, but I just want to preserve that objection to the record.
All right. Again, you're admitting this is material relied upon by this expert, and so the objection is overruled.
Thank you, Your Honor.
Dr. Chen, without going into the details, did you analyze Dr. Lewis's various minimum African American CVAP estimates in relation to your own simulated plans?
Yes, I did.
And if we could pull up Plaintiff's Exhibit 171. Again, without going into the details, in order to do this analysis, did you have to estimate the BVAP and the black CVAP in each of the existing state house districts?
Yes, I did.
And is that reflected on this table?
It is.
If we could pull up Plaintiff's Exhibit 172. And similarly, did you have to estimate the existing BVAP and black CVAP in the existing state Senate districts to do this analysis?
Yes, I did.
And is that what this table shows?
It is.
We could pull up Plaintiff's Exhibit 775. Dr. Chen, what does the first column of this chart show?
The first column here lists the various House-County groupings that were in Dr. Lewis's amended Table 4, which we just saw a moment ago.
And what, if we look at the second and third columns, what do those columns represent?
Well, of course, Dr. Lewis produced his estimates with respect to a hypothetical 2016 general election, which obviously includes state legislative elections. So that's what's listed in the second column. And then in the third column, I've simply reported, I copied over Dr. Lewis's new revised estimated black CVAP threshold, the new revised estimates that were given to me this Monday morning.
So the third column, taking for instance the first row that says 31%, that's Dr. Lewis's corrected estimate of the minimum black CVAP needed for a district in this county grouping for the African American preferred candidate to win. Is that right?
Yes, exactly.
What's in the fourth column, the one that says in the first row 2 and then parentheses HD 21 and HD 22?
I just went into that county grouping for which Dr. Lewis produced this 31% black CVAP estimate, and I counted up and identified the enacted House Plan districts that satisfy Dr. Lewis's new black CVAP threshold. So basically this says HD 21 and 22. That's me identifying that those are the two districts in this county grouping that meet Dr. Lewis's new revised estimate of 31% black CVAP.
And I used the wrong row as an example that I meant to use. If we look at the Lenore-Pitt row, which is about 5 rows down, so you're saying that fourth column shows that there's, so what's the minimum black CVAP estimate for that county grouping by Dr. Lewis?
Sure, so we see that Lenore-Pitt row highlighted, and Dr. Lewis produced a new revised estimate of 28% black CVAP. I went into the Lenore-Pitt county grouping in the House enacted plan, and I found that there were 2 such districts with at least a 28% black CVAP. They were HD8 and HD12. So those are the 2 that I've listed in the fourth column there.
And what is the next column over? The one that says 1,000 parentheses 100%. I'm sorry, I apologize. What does the next column over? The column that says 1,000 parentheses 100%. What does that column represent?
So I just said a second ago that there are 2 enacted House districts that achieve that 28% black CVAP threshold. Now for this next column, the fifth column, I went into all of the 1,000 simulated House plans in House Simulation Set 1. And I identified how many of these 1,000 simulated plans also have 2 or more districts with a black CVAP of 28% or higher. So that 1,000 is telling us that all 1,000 of the simulated plans, 100% of the simulated plans, just like the enacted plan, have 2 or more districts with at least a 28% black CVAP, which was Dr. Lewis's estimated threshold.
What about the next column over that says 392?
It's a very similar calculation, except in this column, I was asking not how many simulated plans match the enacted plan in terms of two 28% black CVAP districts, but how many of the simulated plans actually exceed that number, actually exceed the creation of two black districts, of the two districts of at least 28% black CVAP. And so in 392 of the simulated plans, or 39.2% of the total, I actually found that the simulated plan creates three such districts, three districts with at least a 28% black CVAP each. So that's why I've written 392 there in that column.
So to make sure we're getting this, so you're saying that in all 1,000 of your plans, you produce at least as many districts as the enacted plan.
Yes.
That exceed Dr. Lewis's estimate of the minimum black CVAP threshold. And in 392 of your plans, you actually produce more districts in this grouping that exceed Dr. Lewis's black CVAP threshold?
Exactly. The computer simulated plans have 392 plans that actually created more such districts.
And are the final two columns just represent the exact same thing, but for house simulation set 2 rather than set 1?
Exactly.
As a whole, looking through this chart, what do you find? And maybe if we focus on column 5, the one that we were just talking about, the one that has mostly 1,000s in it.
Sure. What you can see in column 5 is that for almost all of the county groupings that Dr. Lewis analyzed and produced a estimated black CVAP threshold for, the simulated plans in general, either all or most of the simulated plans are matching or exceeding the enacted plans in terms of the number of districts in each county grouping that reach the CVAP threshold, the black CVAP threshold that Dr. Lewis has now produced new revised estimates for.
And if we could pull up Plaintiff's Exhibit 776. What is this table showing?
This is a similar table, except now we're looking at the Senate county groupings that Dr. Lewis just produced new estimates for that I just received on Monday. So these are Senate county groupings rather than the House county groupings we saw in the previous table.
And using, let's say, the Davie-Forsyth row, can you just walk through what you found?
So that's
yeah.
Okay, the second Davie-Forsyth row there, and that is the Davie-Forsyth county grouping in the Senate. So we can see that Davie-Forsyth has 2 Senate districts, and we can see that Dr. Lewis has just produced a new black CVAP threshold estimate of 32%, and I identified in the enacted plans version of Davie-Forsyth that there is one district, SD32, that meets that threshold, 32% black CVAP. And then I went with the computer simulated plans and counted up how many of the simulated plans also do the same. And I found it was 951 of the simulated plans out of 1,000, so that's 95.1% of the simulated plans.
If we could pull up Plaintiff's Exhibit 774. Dr. Chen, as we talked about yesterday at the end of the day, Dr. Lewis also produced separate tables, I think they were tables 2 and 3 from his report, that estimated minimum black CVAP needed, but not for state house and state senate elections, but for prior primaries or general elections for other offices like the Attorney General.
Yes.
Is this table providing the same analysis we just talked to, but using those estimates from Dr. Lewis?
Yes, exactly.
If we could pull up, Dr. Chen, did you do any analysis of whether it would be mathematically and geographically possible to produce reasonably compact districts that have an over 50% BVAP in any specific county groupings?
Yes, I did.
I believe those county groupings were Davie-Forsyth in the Senate and Nash-Franklin in the House. Does that sound right?
Yes, sir.
Without going into all the details of your analysis, what did you find? And I'll point you to page 149 of your rebuttal report, if that helps.
Sure. So let's start with Davy Forsyth. And that appears on 149 of my June report. So all I simply did with Davy Forsyth was to determine whether it was even mathematically possible to produce a 50% black VAP district, an African American VAP district. And that was actually something that I could answer without even getting into geographic properties or contiguity or the compactness of those districts. I simply determined whether it was mathematically possible in that county grouping to produce a 50% BVAP district, and I found that it just wasn't even possible. Even if you were ignoring geographic contiguity, not achieving any particular threshold of REOC or Polsby-Popper, it's just not mathematically possible. Okay. I'll just...
Impossible ignoring.
Okay. Even if one were ignoring geographic contiguity or producing districts of a particular REOC or Polsby-Popper threshold, I found that it was simply mathematically impossible to produce a district of at least 50% black VAP, or voting age population, in the Davy Forsyth county grouping.
How about in Nash Franklin?
So I answered it a little bit differently in Franklin Nash, in the Franklin Nash House county grouping, because it is in fact mathematically possible to have a district with at least a 50% African American voting age population. But briefly, I just found that it was not possible to do so while producing districts with at least a Polsby-Popper score of at least 0.05. And so that is what I found.
All right. I know that's a lot of information. Dr. Chen, are the details of that analysis laid out in your rebuttal report?
Yes, sir.
If we could pull up Plaintiff's Exhibit 225, just figure 153 of Dr. Chen's rebuttal report. Dr. Chen, I believe you analyzed the racial composition of some county groupings that Dr. Lewis did not analyze in his report. Is that correct?
Yes, sir.
And what county grouping does this show?
This exhibit shows the Anson Union county grouping in the House plan.
What's reflected on the horizontal axis going from left to right in this exhibit?
So in this chart on the top, that horizontal axis is reporting the district's African American citizen voting age population, the African American CVAP of individual districts. And we're looking at all three districts in this House grouping, in this House county grouping.
And what's reflected on the vertical axis?
So on the vertical axis, there are 3 rows, and that's because this county grouping has 3 districts. And so for every one of these plans, both the enacted House plan and the computer simulated plans, I'm ordering the districts from most African American in the top row to least African American in the bottom row. And so that's why there are 3 rows. So we can look at the red stars. The red stars tell us the enacted House plan districts, 55, 68, and 69. And those red stars are ordered from most African American on top, that's HD 55, down to the least African American at the bottom, HD 68. And of course, I've done the same once again for all the computer simulated districts in the 1,000 computer simulated plans in House Simulation Set 1. So for every simulated plan, there's 1 gray circle in the top row, 1 gray circle in the middle row, and 1 gray circle in the bottom row, ordered from most to least African American.
Focusing on the top row, what did the data in the top row reveal?
So in the top row, we're focusing on the most African American district within each plan. And when we look at the most African American district in the enacted House plan, that's obviously HD 55, that red star there, and it has an African American CVAP of approximately 25%. Now in that top row, let's look at all the gray circles. You can see there's this cluster of gray circles here to the right. So almost all of the gray circles, almost all of the most African American districts within the simulated plans are more heavily African American than HD 55. Specifically, it's 98.7% of the simulated plans produce a district that has a higher African American CVAP than HD55 does.
And just to clarify, I know you said this yesterday, you didn't program your algorithm to try to create districts with higher black CVAPs. This just happened through a nonpartisan line drawing process?
Exactly. The simulation algorithm was race blind.
You didn't program your algorithm to try to produce higher BVAP districts. This just happened through a race blind computer simulation process?
Exactly. The simulation algorithm was race blind.
Dr. Chen, I'm going to ask you to accept as a hypothetical that legislative defendants have said that, all else being equal, having districts with higher BVAPs helps promote the political power of the African American community. Will you accept that hypothetical?
Objection, Your Honor. You notice with such hypothetical that's been posed or argued by the defendants in this case, that is just completely made up by the plaintiff's counsel.
We're going to overrule the objection, allow a hypothetical.
Will you accept that hypothetical?
Sure.
If you accept that hypothetical, have legislative defendants sought to promote the political power of the African American community in the Anson Union House County grouping?
It appears not.
Pull up Plaintiff's Exhibit 226. Which House County grouping does this analyze?
This exhibit analyzes the Cleveland-Gaston County grouping in the House plan.
And Dr. Chen, just to move it along, so without going into all the details, did you find the same thing here or something similar that you found with the prior county grouping?
Yes, I did.
And if we could pull up Plaintiff's Exhibit 227. Which county grouping does this show?
This exhibit shows the Columbus-Pender-Robeson County grouping in the House plan.
And without going into the details here, did you find the same thing again, that your simulations produce a district with a much higher black CVAP than the enacted plan's House district?
Yes, sir.
And pull up Plaintiff's Exhibit 228. What county grouping does this show?
This exhibit shows us the Duplin-Onslow County grouping in the House plan.
And again, without going into the details, did you find something similar here to the prior county groupings we looked at?
Yes, I did.
I have no further questions, Your Honor, but I'll now move in the exhibits we've gone through.
What's that? Well, Your Honor, we're going to object to Exhibit 2-1, whichever one's Dr. Chen's expert report on the ground of hearsay. I can hand up some cases, Your Honor. There's a federal case by Judge Flanagan saying that the overwhelming rule is that expert witness reports are not admissible into evidence. Plaintiffs have argued for the residual hearsay exception as being grounds to admit this, but there's North Carolina cases that say when the witness is present to testify, that greatly diminishes the need for residual hearsay exception to be applied to any out-of-court statement, much less an expert witness report. There's no need for this. Dr. Chen has testified for well over a day. We don't know what else in his report that the plaintiffs might cite to the appellate court in this case. So we're put at a disadvantage of not knowing exactly what we might need to cross-examine him on. They've had plenty of opportunity to get everything out of his report that they think is relevant to this case. And there's no reason for the court to depart, particularly in this case, from the general rule generally accepted by all courts that expert witness reports are not admissible. I have some other objections, Your Honor, but I'll stand down until you rule on this one.
Mr. Jacobs.
Sure, Your Honor. Several responses. First is I think it has become clear over the last day, obviously Dr. Chen's analysis, our other experts' analysis, their experts' analysis is extremely complicated. It would greatly aid this court and frankly the reviewing courts to have his full reports, all of their reports in the record to be able to review the testimony in that context. In addition, obviously, we're all operating under time constraints here. We have 3 additional experts. I believe the defendants collectively have 6 experts. It would greatly speed up, make the trial presentations much more efficient if we knew that we could all have the reports submitted into evidence. Obviously, we would not object to their reports being submitted into evidence. They can cross-examine Dr. Chen or any of the other experts on anything in their reports. And the last thing I'll say is, Mr. Farr raised, we did notify defendants that we intended to rely on the residual hearsay exception here. It meets all of the elements of that exception. Circumstantial guarantees of trustworthiness. Dr. Chen is here and able to answer any questions that legislative defendants have about anything in his report. It's obviously relevant to many material facts in this case. And another thing I would note, Your Honors, is that in redistricting cases and partisan gerrymandering cases in particular, there are examples. This is something that is fairly standard for reports to be admitted into evidence. I believe, unless I'm mistaken, that it happened in the Common Cause v. Rucco case in federal court. It happened in our Pennsylvania case in Pennsylvania State Court. It just frankly greatly aids the court and the reviewing court to be able to have those reports.
Yes, sir, Mr. Farr. Thank you.
Your Honor, all those cases that counsel just cited were cases where the parties agreed the reports should be admitted. None of those cases are cases where the court allowed the expert reports in based upon the residual hearsay exception. The notice we allegedly got about these reports should come in under the residual exception came to us just a few days ago, within the last week. It's not like they told us that this was going to be their position for an extended length of time. Your Honor, it's not fair in a case like this for the plaintiffs to submit 200 pages of expert reports, 400, I think, I don't have the numbers exactly right. I know that about 200 in Dr. Chen's opening report and over 100 in his rebuttal report, which we also object to for the same grounds, Your Honor. And it's simply not fair in a time trial to make us try to figure out what additional portions of those reports that we should have to cross-examine him on. Our cross-examination will be limited to the testimony he's given in this case so far. And again, Your Honor, it's not fair for the plaintiffs to put something that's hidden in one of these reports that's not been brought out in open court and then attempt to rely upon that in front of an appellate court. They have plenty of opportunity to give Dr. Chen his opportunity to testify on the parts of his report that they think are important. And again, Your Honor, I don't know that they can cite a case. I couldn't find one where an expert witness report has come into evidence over the objection of the other party. Again, that's certainly, as Judge Flanagan, I can give you the citation of that case, Your Honor, if you'd like to have it. But clearly, the overwhelming way of authority is these things should not come in. And we have not found a North Carolina decision where an expert report has come in over an objection to the report on the grounds of hearsay.
Have you found in
North Carolina State Court, not a federal court, where the court agreed that an expert report was not admissible in a federal
Candidly, Your Honor, we did not. We haven't found a state court decision that addresses that. The thing that we've found that's closest is, again, a decision by Judge Flanagan, which I can find somewhere in all this paper I've got, where she reviewed a lot of the cases on it, and she concluded that the overwhelming authority was that expert reports should not come in.
May I respond very briefly, Your
Yes.
Honor? Mr. Farr's statement that there's no case in which they've been admitted over the defense counsel's objection is not true, because in the Pennsylvania case, which Mr. Farr's co-counsel was sitting there with us at trial, they objected to the admission of the expert reports, and we had a lengthy back and forth, and the trial court admitted the expert reports over defense counsel's objection, and we can produce the transcript if that would aid the court where that happened. I'd be happy
I
to.
don't dispute that, Your Honor. I wasn't in that case, and I accept the plaintiff's representation on that.
Okay.
And I'm sorry, just about the timeliness of the notification of the residual exception. We notified defense counsel the day after we saw their list of objections and we saw that they objected to the reports. We told them we would be relying on the residual exception.
I think what we'll need to do is have an opportunity to confer on this, and we can proceed one of two ways. We can rule on that objection later, after we've had a chance to discuss it among ourselves. And the only, if we were to sustain the objection, then the plaintiffs may well say, well, in that case, we need to go into some other topics that are contained in that report if the court is not going to have the benefit of seeing the report itself. So that would be one way of proceeding. Or we could go ahead and take a break and have that conference among ourselves at this time and make a ruling on that. Why don't we do this? Why don't we hear all of the documents that you intend to admit into evidence at this time, hear any other objections to those, and then perhaps the best thing to do will be decide whether we need to take a break and confer among ourselves on this issue.
Yes, Your Honor, and these will be the exhibits that are the ones that relate to the ones that Dr. Chen testified about. And I'll do these in ranges because there's many of them. So they are plaintiff's exhibits 1 through 5, 7 through 18, 20 through 23, 26 through 37, 39 through 42, 45 through 60, 61 through 76, 81, 86, 90, 94 through 107, 117 through 119, 121, 123 through 129, 131 through 133, 140 through 145, 146 through 154, 165 through 173, 218 through 220, 223 through, 222 through 223, 225 through 228, 234, 236, 238 through 239, 241, 244, 246, 248, 569 through 572, 586, 594, 606, 773 through 776. And then I'll list off some other ones, Your Honors, but these are, just to give the context for these remaining ones are the electronic files that are the Hoffler files that Dr. Chen testified about. We submitted to the court with our exhibits a thumb drive that had the actual electronic files on them, like the Microsoft Excel files, the Maptitude files. So I'll list these off now. It's 721 through 724, 730 through 735, and 753 through 756. Oh, I'm sorry, and I missed a couple. 736, 738 through 739, 742, 744, 746, and 748.
Thank you.
Thank you, Your Honor.
Objections to the admission of any of these documents?
Your Honor, just to give everyone a general idea of where we're going, so you understand the basis of my objections. We do not object to any of the exhibits that were part of Dr. Chen's original report. So basically, the objections we're making are to the exhibits that relate to the rebuttal report. And of course, the Lewis documents that we've talked about already. The numbers we've come up with for Exhibit 123, 572, 142, 143, 144, 145, 146, 147, 140, 141, 569, 124, 126, 127, 128, 133, 129, 131, 132, 125, 146, 149, 150, 151, 571, 153, 164, 248, 244, 241, 246, 166, 167, 170, 168, 721, 171, and 172. Now, if plaintiff's counsel can tell me that we got one of those wrong and one of those exhibits are part of Dr. Chen's original report, then we would withdraw the objection to that exhibit if you let us know when I'm done talking. Another one? I just handed up, there's another one, Your Honor. I got no idea what it is, but it was 570. So, Your Honor, I want to say a couple of things about the exhibits we're objecting to. First of all, you've already heard and ruled upon, and we accept the court's ruling, but I'm just stating for the record that we think all of the information related to Dr. Hofler's computer should have been excluded from this case for the reasons we've already stated in the briefing and the argument that's been done on those files. We understand the court's ruling, and I'm really just stating that to preserve our objection for the record. Also, Your Honor, the issue in this case is whether the maps adopted by the General Assembly are legal. As my co-counsel, Mr. Strack, said in his opening statement, all this testimony about Dr. Hofler is a sideshow. And it's a sideshow, Your Honor, because nowhere has there been any evidence that Senator Heiss, Representative Lewis, any member of the General Assembly, my law partner, Phil Strack, has been accused of lying to the federal court quite unfairly. There is no evidence that any of the information on Hofler's computer or his files were shared with any of those people. They have a very prominent and good national law firm. They hired one of the best forensic companies probably in the world. I don't know what a terabyte is, but I'm told it's a lot of information. There's several terabytes of information they've looked through. They've not come up with one piece of evidence showing that Dr. Hofler's materials were ever reviewed or seen by anybody at the legislature or legal counsel. So therefore, Your Honor, this evidence is completely irrelevant to whether or not the maps actually adopted by the General Assembly are legal or illegal under the North Carolina Constitution. And furthermore, Your Honor, it is highly, highly prejudicial to the extent that there's any modicum of relevance to this evidence. The prejudice to the legislative defendants is greatly outweighed because Tom Hofler has been the subject of, I think, malicious attacks in the media and attacks in this courtroom. Is not here to defend himself. So if we had Dr. Hofler available, it certainly would help us explain the points that I've made that the legislature and legal counsel are not aware of the fact that he was drawing maps on his own. We can't have him here to say that. So even if this stuff was in any way relevant, the prejudice to the legislative defendants greatly outweighs any far-fetched relevance that these documents may have. Thank you.
Mr. Jacobson.
Sure, I'll just briefly, I think the only objection sort of that hasn't been addressed by the court is the relevance objection we just heard. I'll be brief. I mean, legislative defendants hired Dr. Hoffler to draw these maps. They paid him $50,000 in taxpayer money to draw these maps. Obviously, what the map maker was doing when he drew the maps is the most directly relevant evidence that you could possibly have in a partisan gerrymandering case. If the map maker was acting with partisan intent, that goes to the core questions that this factual and legal that this court will address. These documents are frankly smoking gun evidence of partisan intent, of failure to comply with the adopted criteria, and of lots of other things. I frankly can't think of evidence that would be more relevant in a partisan gerrymandering case. We dispute the premise that legislative defendants didn't know about these activities, but that's sort of neither here nor there for present purposes. It doesn't really matter for relevance purposes. If general agency principles, if you hire somebody to do a job, which is what happened here, then obviously their activities, their state of mind, what they were doing is relevant. And then the last thing I'd note, which your honors I think have already somewhat ruled upon, is that all of these documents are public records under the statute, under Dr. Hoffler's contract. And the notion that we wouldn't admit public records that should have been made public, frankly, the day these maps were passed, I think there's no basis for that.
All right, very well. Yes, sir. Yes, sir.
This is going back to our hearsay objection on the reports. I've got copies of the two cases I was relying upon. I'm sorry I don't have one for plaintiff's counsel. I'd be happy to give them to these before we hand them up to the court. But the case by Judge Flanagan is called SMB Software, the EMOVE Inc. And the citation's 2014 Westlaw 126334915. The state court, there's several state court cases that say what I've said, Your Honor. We haven't found one about an expert witness report. They simply define when residual exception applies, and they basically say that if the person's there to testify, it greatly diminishes the need to employ the residual exception. The case I've got is called State v. Smith, 337 Southeast 2nd, 833. And I'd like to let the plaintiff's counsel review these, and then after that, Your Honor, we'd like to hand these up to the court in case they may be of some benefit to you.
Thank you.
Thank you.
Counsel.
Your Honor, may I just clarify one thing? I should have said, we're seeking to admit both Dr. Chen's original report and his rebuttal report. Those are exhibits, plaintiff's exhibits 1 and 123.
Yes, sir.
I don't think I listed those on my list. And then I missed two exhibits from Legislative Defendants Council that Dr. Chen talked about. That's Legislative Defendants Exhibit 1 and Exhibit 159.
159.
150, Legislative Defendants 159.
All right. You did mention 1 and 123.
Okay.
So those are on the list. Mr. Farr.
We object to 123, Your Honor, and we don't object to any. Again, I have no idea what they are, but if there are exhibits, we don't object to them.
I think it's just the map.
Okay, that's the legislative defendant exhibits. You're saying you do not object to those, but
I don't know how, but I can't, Your Honor.
no, I understand. But you do object to the two reports, the original report, which is Exhibit 1, and the rebuttal report, which is Exhibit 123.
Yes, sir.
All right, and then I understand that the other. All right, I think we're clear then.
And Your Honor, just to clarify, the 123, I won't repeat the hearsay objection, but I want to make it clear that we object to the part of that report that deals with Dr. Lewis. It's a rebuttal report, and Dr. Lewis is not going to be testifying, so there's nothing to rebut.
Yes, sir.
Thank you, Your Honor.
Very good, thank you. All right, what we'll do then is take a recess of 15 minutes to allow us the opportunity to confer, and then we'll hopefully be ready to go back on the record.
Thank you.
All right, welcome back, ladies and gentlemen. So we've had an opportunity now to review the various categories of items that were objected to by the defense, legislative defendants. And let me ask Mr. Branch, and perhaps we should have done this a few minutes ago, are there other documents that you would raise objections to other than the ones that we have just heard from Mr. Farr?
No, Your Honor, I just want to get the record that the intervener defendants adopt the objections raised by the legislative defendants and as well as the arguments made by Mr. Farr. We believe that they apply to our clients as well.
Thank you. And Mr. Cox, for the state, any objections that you wish to raise at this time?
No, Your Honor.
All right, thank you. All right, so let's start with the reports, both the item number 1 and item number 123, which are the reports of Dr. Chin and the rebuttal report. North Carolina law differs from federal law in one significant respect with regards to prior statements of witnesses. We find that at a minimum these reports can be or should be received into evidence as prior statements of a testifying witness used to corroborate the testimony of the witness who has already testified. We'll note that the case law in this area states that the prior statements need not relate to specific facts brought out in the witness's trial testimony so long as the statements tend to add weight or credibility to such testimony. So they are received for corroborative purposes. We are still considering the issue as to whether there's an independent basis for receiving them as substantive basis, and we are not making a ruling on that at this time, but we are receiving them for corroborative purposes. A case cite for you, our North Carolina Supreme Court State versus Gell, 351 NC 192, a 2000 cases. There are a number of times that this arises in the criminal context, so there are a number of cases that state that law fairly decisively under North Carolina law, not under federal rules of evidence. So that relates to the two reports. A number of objections related to exhibits that were discussed by Dr. Chin that appear in his rebuttal reports, and those were published to the court and discussed by Dr. Chin. We are receiving those and allowing those into evidence. We've already ruled on the several items of evidence that relate to Dr. Lewis's corrected report. We've already ruled on the admissibility of that, forecast our ruling at least, and we would receive those into evidence as well. The remaining objections related to Dr. Hoffler data. We, in a previous motion in limine, discussed that the court have ruled that we were satisfied that authenticity and chain of custody has been forecasted sufficiently to satisfy the admissibility of those documents. We do find that they are relevant. We do find that they are therefore admissible. We've conducted a balancing test under Rule 403 and find that the probative value of those exhibits outweigh any undue prejudice, and so we would overrule any objection on that basis as well. I believe that covers all of the categories of objections raised by the legislative defendants and the intervening defendants, and so each of the documents that were identified by the plaintiffs are admitted.
Your Honor, may we have leave to amend our exhibit list so that we can introduce the reports by our experts who were not previously identified as exhibits on the ground, so we thought they were hearsay?
Yes. Any objection to that? I believe you said that you would consent to that.
The one caveat is just that as long as the experts here to testify.
Yes.
cross-examine them.
Right. We would extend the same ruling to expert reports of any defendant and intervening testifying experts. They would be received on the same basis as we have just announced for Exhibits 1 and 123. And again, we are continuing to consider whether they may be admitted for substantive purposes as well, but certainly for corroborative purposes, they would be received.
Thank you, Your Honor.
All right. All right, very good. So I believe we're ready for cross-examination of this witness. Is that correct? So we'll ask Dr. Chen to resume his seat. Mr. Farr?
Good morning, Mr. Farr.
I have a few questions for you today. First, I wanted to ask you, Dr. Chen, do you have any background in computer forensics?
No, sir.
And you did not personally search Dr. Hoffler's computer devices?
Never had access to them.
The files that you testified about today and yesterday from Dr. Hoffler's devices were given to you either by plaintiff's counsel or their vendor, Strauss Friedberg, is that correct?
They were all given to me by Strauss Friedberg.
Do I need to use those? Can you hear me, Dr. Chen?
I think you can just leave that on the table, that's simply for the broadcast.
Okay.
Your microphone in front of you is the one that you need to speak into.
Okay. Now, Dr. Chen, you do not have a license from Aptitude,
I don't currently.
and you've not had a Aptitude license for at least a few years.
That sounds about right.
You've never drawn a legislative or a congressional map for a legislature using the Aptitude software.
That is correct.
And some of the screens are, correct me if I'm wrong, Dr. Chen, because I'm wrong more than often. But the screens that you testified about today and yesterday, were those screens that were made on Mr. Esterline's computer?
So you're talking about screenshots that we've been looking quite a bit
Yes.
at the last couple of days. I'm sorry, the last 2 days here, or I believe all just yesterday. And all of those screenshots that I have in my report, those are all screenshots that I looked on Mr. Esselstein's computer. I directed Mr. Esselstein to take those screenshots.
Right. And you weren't present in the same location with Mr. Esselstein when you directed him to take those screenshots. You were in Michigan and he was in Asheville?
Well, the way that computers work is you can actually be in a different state and actually see a different computer, even though you are geographically in a different location. So I was actually looking at Mr. Esselstein's computer.
But you were in a different location than Mr. Esselstein.
Again, the point is that you can actually look at another person's computer even though you are in a different location. And that is that is my normal practice.
And you agree, do you not, that when someone is using Maptitude to draw a map, they can exclude both racial and political data from the screen that they're looking at when they're drawing the map?
Which screen are you talking about? I just want to understand your question.
Any screen that's on the computer that the map drawer is looking at when he's drawing a map on Maptitude, he can exclude racial data and political data, can he not?
Well, there are a couple different screens. I'm asking you which one you're talking about. All I can tell you with respect to the screens that we've been looking at the last couple of days. I mean, certainly it's the case. I talked to you, or I explained to the court yesterday how there's a map window. Now, that map window, you can create a racial label for the districts in that map. And certainly that means you don't have to create that racial label. So if that's what you mean by turn on and turn off, certainly that's true.
And it's also true that you can, in that window, exclude political data if you choose to do that.
You could create a political label. You could not create a political label.
So you were not present when Dr. Hoffler drew any of the maps that you testified about today?
I was not sitting with Dr. Hoffler or looking on as Dr. Hoffler was drafting the maps.
So you don't know what he was looking at when he drafted the maps?
That's actually not true. I think what I was explaining yesterday is that there's quite a bit that we can say about these windows, about these specific windows. And if you recall yesterday, I talked at length about a map window as well as a data view 1 window. And when you open those two windows up from a Maptitude backup file, one of these .bak.zip files, several of which I wrote about in my report, we can actually say that we know what the data view 1 window looks like and what the .map window looks like.
But you have to open that up.
Well, you have to open up Dr. Hoffler's Maptitude backup files in order to see those things.
Okay.
But once you open them up, then you can see what that data view 1 window looked like and what that .map window looked like.
You did not look at every draft map that came off of Dr. Hoffler's computer devices.
So I'm not going to be able to have the basis to give you an accurate answer to that, to that question, because I don't know to the extent to which I have actually been given all or only some of the files from Dr. Hoffler's devices.
So there could be draft maps on Dr. Hoffler's devices that you were not given by plaintiffs or their vendor,
Same answer.
which was that's a yes.
I mean, what I told you was that I received the files that I received and I reported on in my report. I told you that they came from Stroh's-Friedberg. I can't tell you anything else about what other files might be on or might have been on Dr. Hoffler's devices because I did not receive Dr. Hoffler's devices. I received files that came from Dr. Hoffler's devices.
Okay. So I now want to ask some questions about race. Could you turn to, could we hand up the exhibit next, please?
Thank you.
So Dr. Chen, let's turn to tab 2. And I think this is labeled as Legislative Defendants Exhibit 155, and I believe it was Plaintiff's Exhibit 4. And you've looked at this exhibit previously and during your testimony, correct?
Yes, sir.
Okay, and this is the adopted criteria for the House and Senate plans, right?
Yes, sir.
Is it fair to say that there's 9 criteria listed?
I didn't count them up, but I'll take your word for it.
Well, I could be wrong because I don't count well. It's 8 or 9. And each criteria's got a heading,
I see that.
and then there's a text,
Yes, sir.
and the text explains what the criteria means?
Well, I think it's fair to say that there's text that follows each one of these headings.
Okay. And so let's go down to the last criteria. And would you read that, please?
Sure. No consideration of racial data. Data identifying the race of individuals or voters shall not be used in the drawing of legislative districts in the 2017 House and Senate plans.
Okay, so now I'd like to bring up a transcript that counsel asked you about yesterday. I believe it's Plaintiff's Exhibit 606. And did you recall testifying from this exhibit yesterday?
And if you could point me, which tab am I looking at?
No, it's going to be up on the screen. I don't have this on the tab.
Okay, sure. All right, I remember this.
Okay. And that's a hearing dated April 24, 2017, Senate Committee on Redistricting. Is that right?
I think you said April. It's August 24th.
Oh, I meant to say August. I'm sorry.
Okay.
So did you read this whole transcript, Dr. Chan, or did you just read certain portions of it?
I didn't read the whole thing. I think I only read around the areas that I quoted.
Okay, so let's turn to the area you quoted, which is on page 102, and it begins at line 15. And could you read into the record again, I think this is what you quoted, where it says Dr. Huffler was given the criteria. Could you read the rest of that through the end of that paragraph?
Which lines are you asking me to read?
It's 102, line 15 through 22.
Okay, sure. Dr. Hoffler was given the criteria of this committee, which was significantly different from the criteria of the previous committee. As a result, the court rulings, and from the criteria, drew maps that did not include race. Race was not part of the database. It could not be calculated on the system that is done.
Okay, so it's fair to say that Dr. Heiss said that, or Senator Heiss said that Dr. Hoffler drew maps that did not include race. Is that a fair statement?
Let me just review that again. Okay, sure, I see those words.
Okay, and then he says race was not part of the database. Do you see that?
I see that sentence.
Okay, now, do you have any evidence, or have you been given any evidence by plaintiff's counsel or the vendor they used that Representative Heiss ever had access to Dr. Hoffler's private computer devices?
I'm sorry, if you could just repeat, Representative Senator Heiss, is that what you said?
Are you aware of any evidence that Senator Heiss had any access to Dr. Hoffler's private computer devices that you testified about?
The only relevant information I was given by plaintiff's counsel was that the General Assembly hired Dr. Hoffler.
Right, but you don't know, you have no evidence, they've not given you any evidence that Senator Heiss had access to Dr. Hoffler's private computer devices that you have testified about.
So yeah, I don't know if that is part of their arrangement or not. I just know that the General Assembly hired Dr. Hoffler.
Right, and do you know that there was a computer at the state legislature that was used by Dr. Hoffler under the supervision of Senator Heiss and Representative Lewis to actually draw the maps that were published to the General Assembly?
I don't specifically know any details about that.
Okay, so did your plaintiffs, or did the plaintiffs' counsel or their vendor give you any files from the state's computer that was used by Dr. Hoffler under the direction of Representative Lewis and Senator Heiss?
So I'm not sure that I was told anything about the specific computer that the files were on. What I've been given are files that I'm told came from Dr. Hoffler's hard drives. I don't know what computers or computer those files were attached to, or that hard drive or those external drives or those devices were attached to. So I can't tell you anything about the computer. I can just tell you about the files on the hard drive.
Right, so if Representative Lewis and Senator Heiss used a computer owned by the state to supervise Dr. Hoffler to draw maps, you have no idea whether there was racial data on that computer or whether there was no racial data on that computer.
So I can't say that I have no idea or do have an idea. I think I've told you what I know is that I see the files. I know where the files came from. I don't know which specific computer those devices that the files came from were attached to.
And you have no evidence that the files you looked at that were given to you by plaintiff's attorneys and their vendor from Dr. Hoffler's private files, you have no evidence that those files were downloaded onto any state computer that was supervised by Representative Lewis or Senator Heiss.
Same answer as before. Like I said, I've been told that these came from Dr. Hoffler's devices. I can't tell you what computer those devices were attached to.
Okay. All right. Now, I want to have you look at a couple of other parts of this. The part that Senator Heiss's testimony that you referenced, was that pointed out to you by plaintiff's counsel?
Plaintiff's counsel sent me that transcript.
Okay, and they sent you that section, which you relied upon.
They sent me that whole transcript.
Okay, but who pointed out for you which section to read?
Well, I think plaintiff's counsel generally told me to review a couple sections. I don't remember exactly all the different sections, but plaintiff's counsel pointed me to this transcript. And
okay, Right, let's look at a little bit more at this transcript. Let's first go to page 7, line 21. And I hope you can see this on the screen.
And is this is not in my binder?
No, I'm sorry,
Okay.
Dr. Chen, it was your counsel's exhibit, and I was hoping that you'd be able to look at the screen.
Okay, sure.
Okay, now, do you see where,
Your Honor, I'm sorry, I don't mean to interrupt. We have a copy of it here, and I forgot to put this in case he wants to have it.
I have no objection to that, Your Honor.
Oh, it is. If you could just tell me which exhibit it is, I could just find it in my.
Exhibit 606, which should be in the second binder.
Thank you, counsel.
Final tab.
Sure, if you could just give me a moment, Mr. Faw.
Sure, take your time.
Okay, and if you could tell me which page.
Well, first of all, let's look at page 4, line 12, and all I want you to do is confirm for me that this is the beginning of a statement by Senator Heiss.
Sure, I see that Senator Heiss starts talking at line 11.
Okay, and so now let's turn to page 11, line 2, and I'd like for you to read from line 2 through line 9.
Okay, and you're telling me that Senator Heiss is still talking here on page 11?
You're welcome to review that, but I can represent to you that he is. If you want to
Sure.
confirm that, you're certainly welcome to do that.
And you want me to start at line 2?
Line 2 on page 11 through line 9.
Okay, so you want me to read that in the record here?
Yes, sir.
Okay. Criteria number 9, no consideration of racial data. Data identifying the race of individuals or voters shall not be used in the drawing of legislative districts in the 2017 House and Senate maps. In the drawing of these maps in the Senate, we do not consider race of individuals in the drawing of the maps or the assignment of voters to a particular district.
Plaintiff's counsel didn't ask you to review that section of the transcript, did they?
I don't specifically remember. I may have looked at it. I might not have. I just don't remember.
Okay. Now let's turn to one more page from this transcript. 14, line 15 through 15, line 4, and you'll see that's Senator Blue asked a question and Senator Heiss responded. Could you read that into the record, please?
Okay, you want me to start with Senator Blue's
Yes.
question there?
Yes.
All right. Yeah. Did you at any point in drawing these districts or the map drawer determine what the court was looking for when it said that certain districts were racially discriminatory and how you would cure that remedy?
And then Senator Heiss says,
Okay. Senator Heiss responds, what we have received, and I would state it in this manner, is that we received from the courts that race was overutilized in the drawing of districts, standards that we had previously presented, as well as having a target race. So we have, in this case, given the changes in the Voting Rights Act or others, we have not drawn this with any consideration of race. So therefore, we did not overutilize race in the drawing of the maps.
okay, thank you. Now, just to make sure this is clear, Dr. Chen, you've not testified about any evidence indicating that Dr. Hoffler shared any of the files on his personal devices with Senator Heiss.
I think I've told you what I know already, which is that Dr. Hoffler was working under the direction of the General Assembly. I know that much. I can't tell you anything specific about the nature or the proceedings of that relationship.
Okay, I think that was just a yes or no question, Dr. Chan, so let me try it again. do you have any evidence about whether or not Dr. Hoffler shared information from his personal devices with Representative Lewis? That's a yes or no answer.
Well, and I'm just telling you what I know and what I don't know. I know that Dr. Hoffler is working for the General Assembly. I don't know if the process of working for the General Assembly might have or might not have included the sort of hypothetical that you're asking. So
Okay.
that's as much as I know.
I'm not asking a hypothetical. I'm just asking if you know of any evidence indicating that Dr. Hoffler called up Representative Lewis and said, come on over here and look at my personal devices. Or here, I'm going to email this stuff to you. Are you aware of any evidence like that?
And like I said, Mr. Farr, my evidence, my answer to your question is that the only evidence that I've got for you that might be relevant is that plaintiff's counsel told me that Dr. Hoffler was working for the General Assembly. That's all I've got, and that's what I told you.
Okay. And that would, you'd answer my question the same way for any other legislature or for legal counsel.
Yeah, I mean, I've told you what my understanding or my information is regarding Dr. Hoffler's relationship to the General Assembly.
Okay. When did Dr. Hoffler sign his contract to work for the General Assembly and drawing the 2017 plans?
If I'm recalling correctly, plaintiff's counsel told me that that date, I believe, was June the 27th of 2017.
Okay. I think that's right, Dr. Chen. Now, you've testified you didn't use race when you did your simulated districts.
Well, the initial set of simulated plans was race blind. Now, I think that's what you're talking about. There is a second set of simulations very briefly discussed. Sorry, it's not briefly discussed, but it is a small set of simulations within one county grouping that was described in my June response report. And that was a completely separate, different research exercise that did, in fact, consider race.
Okay, and because you looked at race after you drew your maps, that's not an indication that you drew the maps based upon race, is it?
Well, the point is that the simulation algorithm itself is not one that considers racial data. So there, I'm able to tell you, here's the simulation algorithm, the part that produces the maps, there's the computer code, and you can see that the computer code doesn't have racial data.
Okay. Now, do you know, or perhaps I'll represent to you, let's do it that way, I'll represent to you, Dr. Chen, that during the legislative debate, and we'll show this with the records that will be submitted into evidence, that several Democratic members requested that racial data be published for the proposed 2017 plans. Are you aware of that?
I wasn't, but I'm happy to take your word for it if that's
Okay.
what you're telling me.
And will you accept my representation that they said, these Democratic members, that they needed the racial data to determine whether the new maps fixed the illegal racial gerrymanders that were found by the Covington Court?
I mean, I know nothing about that, but I'm happy to take your word for it if that's what you're telling me.
Okay. Now, and are you aware of will you accept my representation that the racial statistics for the plans were in fact published before either plan was ratified by the General Assembly?
I'm not sure I caught the last part of your
I'm sorry,
sentence,
Dr.
if you could
Chen.
just repeat.
And Madam Court Reporter, I know you have a hard job, so if I'm going too fast, let me know, okay? Will you accept my representation that the racial statistics for both the Senate and House plan were published for the entire General Assembly before either plan was ratified?
Same answer there. I didn't know, I don't have any information about that, but I'm happy to take your word for it.
All right. Now, in the files that you received from plaintiffs' attorneys and from their vendor, did you see any evidence on that Dr. Hoffler was drawing districts to hit a racial target?
I saw evidence that
That's a yes or no answer, and then you can explain it, Dr. Chen.
Objection, Your Honor. Witness should be allowed to answer the question.
Sustained. You may answer the question. Go ahead, sir.
So what I saw was that there was racial data along the draft districts. Regarding the draft districts that Dr. Hoffler was drafting, I saw that Dr. Hoffler had labeled districts in a map regarding, with respect to the racial composition, the any part African American share of the voting age population. And as I explained to the court yesterday, I also saw that Dr. Hoffler had ordered the districts from most African American to least African American. Now, that tells me certain things about what Dr. Hoffler had done with that data. Beyond that, I can't tell you how else Dr. Hoffler was using that data.
Okay, so the question is, do you have any evidence that Dr. Hoffler was trying to draw districts to hit a specific racial target?
Right, and I'm saying that the evidence that I just talked about, that may speak to your question, but there's not a specific racial target that I saw Dr. Hoffler actually trying to achieve.
Okay, thank you. And did you analyze whether or not Dr. Hoffler was dividing VTDs or cities to separate people because of race?
I'm not sure that's a question I specifically analyzed beyond what I saw Dr. Hoffler calculating and looking at in terms of district level racial composition or district level racial statistics.
Well, so yesterday,
I think the court reporter wants me to repeat.
I'm sorry.
So I'll try and do the best to remember what I just said. What I said was, beyond analyzing district level racial numbers, I think that was the last part of what I just said.
Okay. And the court allowed you to testify yesterday about whether something was plausible or not, is I think the word that you used. And what I wanted to ask you, Dr. Chen, is it plausible that Dr. Hoffler drew the maps and then picked up the racial statistics to just see what the racial stats were for the districts he'd already drawn? Is that plausible?
Yeah, I think I'm going to ask you to repeat your question.
Okay. Is it plausible that Dr. Hoffler drew the districts without using race and then called up the racial statistics just to see what the districts looked like from a racial perspective?
Oh, okay. I think I understand your question. So here's what I can tell you that I saw in looking at Dr. Hoffler's Maptitude backup files. I can see that there are some Maptitude backup files in which there's a pending changes window. And just to explain what the pending changes window is it is something that explains the characteristics of districts as they are being actively updated. And so I can see that pending changes window open, and that pending changes window, in some of these Maptitude backup files, you can see that the pending changes window is open and it is showing or displaying the characteristics of whatever district is being actively updated. That pending changes window would include things like racial data and partisan data.
Right, and so my question is, isn't it possible that Dr. Hoffler drew the maps first and then pulled up the racial data just to see what the racial characteristics were of the districts he had drawn? Isn't that plausible?
Well, I mean, I think what you're kind of suggesting is that even though this pending changes window might have been available, did Dr. Hoffler just shield his eyes or cover up that pending changes window with his hand and blind himself to what was in that pending changes window in Maptitude? And I'll grant you that I guess that could theoretically be hypothetically possible.
Okay. I've got a couple of exhibits that I want to ask you about. Let's start with Plaintiff's Exhibit 571, please.
And if you could give me a moment.
We're going to hand you a copy, but you're welcome to use whichever one you want, Dr.
Okay, I'll just take your copy of it.
I'm sorry, counsel, it's 571. We're going to give you a copy, I hope.
Yeah. Thank you.
Thank you.
Now, Dr. Chen, I got to confess, you know way more about this than I do, so if I ask the question the wrong way, I'm sure you'll correct me. But I recall you testified about this yesterday, and this was a screen from Aptitude that related to a plan called State Senate.
Well, the plan, as Dr. Hoffler called it, is, quote, NC Senate J23. And if you look at the top of that plan settings window, that's where you'll see that.
Okay. And then in the comments sections, you said that these are predecessor maps to J23?
It's basically telling you the lineage of where these plans were copied from. I wouldn't really call it a predecessor. I'm not sure that's a totally accurate or way to describe it. The way that I would describe it is this is just a lineage of where these plans were successively copied from. So the current plan that we've got here, it was most recently copied from the one that you see at the very bottom. But I think you
Okay.
got the right idea.
All right, that's the question I have. So the oldest version, or the oldest map from which it was copied, would be the final NC Senate adopted plan. Is that right?
No. So it goes in chronological order. So the most recent one that it was copied from was at the one at the very bottom, the bottom row where it says copied from NC Senate June the 1st. June-1.
Right. I'm sorry, Dr. Chen, that's what I meant to ask you. So I understand your testimony now. Did you ever review NC Senate adopted? Did you get that file?
No.
So you don't know what was on that file?
My testimony is just based on what I'm seeing here, and I'm looking at the name of the plan that as it's described here in Dr. Hoffler's comment section.
All right. So you don't know what screens Dr. Hoffler was looking at whenever he did final NC Senate adopted?
You're saying when he copied that?
Right.
Right. And this is talking when you're going 3 rows up at the very top of the row, at the very top row in the comments section, you're talking about a copying process that occurred basically 3 generations back, or 3 steps back on the lineage of where this plan came from. So that's a completely different copying process than the one that created this particular Maptitude plan that we're seeing here on the screen.
Right, I got you. But you never reviewed the file for final NC Senate adopted.
Like I said, I don't have that particular plan or that particular Maptitude backup. I'm going on what I actually see here, the words that I see in the comments box.
Okay, and then you didn't have the file or review the file for 2016 Senate minimal change.
Same answer there.
And you didn't review the file for NC Senate June 1.
Same answer.
All right. And Dr. Hoffler was not hired by the General Assembly until June 28th of 2018?
I think you're almost there. What I said was June 27th.
I think you're right. I'm sorry. I get that date confused with the date the Covington decision came out. So you're correct, Dr. Chen. Let's hand out Exhibit 572 now.
Thank you.
Do you have that in front of you, Dr. Chen?
Yes, sir.
Okay, this is pretty similar to Exhibit 571, except it's got a new file listed, NC Senate J23. Is that about right?
Yeah, and you're looking at the comments box, and I can see that the bottom row says copied from NC Senate J-23.
All right, and so did you look at that file?
If you'll give me a moment, I'll give you an accurate answer if you give me a moment to review my second
Absolutely.
report. Okay. So what I'm going to do is I'm going to grab out my report and I'm going to look through all the various Maptitude backups that I mentioned, that I reviewed, and I'll
How
tell
about,
you.
Dr. Chen, do you remember you did a listing for me?
Sure, yeah.
If I could point you to that, would that be helpful?
That might. I really don't think this will take that long, but if you want to put that exhibit in front of me from our deposition, I'm happy to look at that.
It's tab 11 from the witness notebook, and it's our exhibit 160.
Mr. Farr, I think tab 11 is just.
What's that?
There's nothing in tab 11.
Well, it isn't mine.
We can look on the screen.
Is there anything under tab 11 for you, Dr. Chen?
I do have the tab 11 that I think you're referring to.
Yes.
But I'm going to tell you, Mr. Farr, even though you've got this exhibit here in front of me, and I appreciate that, I'm still going to go back and refer to my June 7th report so that I can point to.
Before you do that, and I want you to do that, but could you just tell the court what this exhibit is so we don't have to come back to this again?
Okay, sure. This is it's just a piece of paper that during your deposition of me about a month ago or whenever it was, I listed out a number of the Maptitude backup files from Dr. Hoffler's hard drive that I referenced and discussed at some length in my report of June the 7th. So I was just copying some files, some file names that I had already listed in my report, and I wrote them onto this yellow sheet of notebook paper.
And correct me if I'm wrong, but weren't these the files that you had received from the vendor?
Well, yeah, all of these files I received from Stroh's Friedberg.
Okay, now you're welcome to look at your report.
And these were not the only ones, certainly, but these were among the files that I
Okay.
received from Stroh's.
All right.
So I'm going to look through my report, and I'm going to answer your question with respect to that J23 Senate map.
Okay.
And try to point you specifically to a portion of my report. So if you'll just bear with me a moment. And if you'll just refresh my memory, Mr. Farr, you were asking me about the last line in the comments section on Exhibit 572. Did I get that right?
Right. I think you've answered about the other files already, so I'm just interested in that last comment about NC Senate J23.
Okay, and your question to me was simply whether I had reviewed that NC Senate J23 plan?
Yes.
Okay, so here's what I can tell you. I'm going to point you to page 45 on my June the 7th report. And this is a section in which I start talking about the NC Senate J23 draft plan from Dr. Hoffler's hard drive. And it specifically, I saw a version of that NC Senate J23 plan in a backup file, a Maptitude backup file, that was where the file was called NC Senate J23 005.bak.zip. So obviously, I wrote about that particular Maptitude backup plan at length in my report. And so that's a J23 plan. Now, I'll qualify by saying that, again, obviously I wasn't sitting with Dr. Hoffler. I don't know whether he did this copying of exactly the same version or this same backup of this NC-J23 plan, or if it was a different or an earlier version of the plan that he called J23. But I can see that these two plans are both called NC Senate J23. So
Okay.
that's what I wanted to point out that I think is responsive to your question.
Yes, sir, it certainly is, Dr. Chen, thank you. I wanted to, is this from his rebuttal report? Could you look at figure 29 in your rebuttal report?
Okay, sure.
Now, that is listed NC Senate J23005.BAK.zip. You see that?
Yes, sir.
Now, is that the version of J23 that you reviewed?
Yeah, so the answer is yes, and if you like, if you're about to explain, you ask me to explain that, what that means, I'm happy to do
Well,
so.
no, I'll let your attorney ask you that question, but the other point I wanted to make is, does that not say that that map was last backed up on August 13th, 2017?
Yeah, it does. What that means is that Dr. Hoffler closed this plan on August the 13th. It triggered a backup. And so that's why I explained to you a minute ago, I don't know exactly which version of this J23 plan that Dr. Hoffler used to copy and thus create this new plan that we see in Exhibit 572. I can see it's from the same series. It's from this same J23 series.
Okay. Now, turning back to Exhibit 572, if you've got that with you, Andy. You see where where it states that the date last modified for this particular plan was June 24th, 2017?
Yes, I see that.
And that was 3 days before Dr. Hoffler was engaged by the General Assembly?
It is 3 days before June the 27th.
All right. Could I hand out Plaintiff's Exhibit 569?
Thank you.
Do you have that in front of you, Dr. Chen?
Yes, sir.
So that's a screen that you testified about regarding a plan called State House?
Well, it's actually a plan that Dr. Hoffler called NC House J-25.
Okay. Thank you for that clarification. And in the plan type window, it says State House.
It is a house plan, yes.
Okay. And were you able or did you examine all the files that are reflected in the comments section there?
The answer is no, I just examined the comment section itself.
So you did look at the files for those maps?
No, I didn't analyze the files themselves, I analyzed just the comment section.
And then there's in the window that says date created, it says June 25th, 2017.
I see that, yes.
That was 2 days before Dr. Hoffler was hired by the General Assembly.
It is 2 days before June the 27th.
Okay. And do you know when there's an entry for final NC House adopted, do you know when that plan was created?
Presumably that final adopted House plan was created back in 2011.
Okay. And do you see where it says 2016 House minimum change? Can we presume that that was made sometime in 2016?
Beyond the number 2016 being there, I'm not sure I really have the basis to give you an accurate answer.
Okay. And what about skipping down where it says NC House June 17? Can we presume that that map was created on June 17?
Again, beyond the June 17th being there, I'm not sure I can give you an accurate answer, but in addition, I can tell you that sometimes Dr. Hoffler's naming system for his Maptitude backup files did, and sometimes it did not actually correspond to the apparent date that he wrote. For example, June 17, J2, J5. Sometimes that was, and sometimes it was not an accurate reflection.
Okay, but if this was one of the times where June 17 accurately reflected the date he created this plan, that would have been 10 days before he was hired by the General Assembly?
Sure, I mean, if that's the case, and I'm just telling you beyond the fact that the words June 17 are there, and I should add that NC House June 17 is something that Dr. Hoffler wrote. He wrote the name of that plan. He created the name of that plan. That's not something that's automatically generated by Maptitude. But beyond the words June 17 being there, like I said, I'm not sure I have a basis for affirming or denying.
All right, so Dr. Chen, will you accept my representation that the Covington court decision came out on June 28, 2017?
Objection, Your Honor. I don't believe that's accurate. I just want to clarify for the record.
Well, do you have-
If I'm wrong, we can go back and look, but my understanding is the Covington decision actually came out at the beginning of June.
Okay, well, the record will reflect what it is.
Yeah.
I'll just tell you, counsel, I looked it up yesterday on the internet, and that's where I got the date. I may have misread it.
Hey, we'll clarify it later. If I'm wrong, I'll clarify.
We'll allow the hypothetical question and proceed.
And Your Honor, if I'm wrong, I apologize, but I'm not the most expert person on using the internet, but I did try to look up that case yesterday, and it seemed to me that it was issued on June 28th. So, Dr. Chen, you're aware that Dr. Hoffler drew the map in the Covington case, are you not?
I'm happy to take your word for it.
Okay, and you're aware that he was criticized and the state was criticized for dividing precincts and cities by race and drawing uncompact districts?
I'll take your word for it.
And you're aware that Dr. Hoffler was a lifelong map drawer?
I'll take your word for it.
Now, using your term, isn't it plausible that prior to the time that Dr. Hoffler was hired by the General Assembly, he was drawing maps on his own to see if he could come up with a map that would address the criticisms that were leveled at him by the Covington court? Isn't that plausible?
I really can't speak to Dr. Hoffler's motivations. I just don't have any basis there for saying whether it is even plausible or not.
Okay. Now, let's go on to a different subject about these draft maps that Dr. Hoffler did that you reviewed. Did you attempt to analyze whether in drawing Dr. Hoffler's draft maps, and by that, Dr. Chen, I mean the maps are on his private devices that we've been fighting about in this trial. So when I say his draft maps, that's what I'm referring to. Did you?
Mr. Farr, I'm not sure I caught what your clarification there
I'm
was.
sorry, Dr. Chen, thanks for asking. When I'm referring to his draft maps, I'm referring to the ones that are that were found on his personal devices.
Okay, sure.
All right. Now, did you look at Dr. Hoffler's draft maps to see if in drawing his maps, he felt constrained by the North Carolina County Group formula?
In general, I looked at, obviously, a large number of files from Dr. Hoffler's devices, and certainly I could see that he was working within the whole county rule, that he was working within county groupings. That's pretty clear. The point is that within these within these county groupings, I could see in Excel files that within these county groupings, Dr. Hoffler was considering his draft districts with a predominant focus on partisanship.
Okay. And when you say predominant focus, you're using your definition of that term, not a legal definition.
Exactly. The same clarification that I made yesterday morning, which is that anytime I use that word predominant partisanship, I'm talking about my own empirical conclusions.
Okay, but you admit that Dr. Hoffler's draft maps appeared to be constrained by the county grouping formula.
I wouldn't say constrained. Like I just said a moment ago, he was following the county groupings as a whole, and within the county groupings, Dr. Hoffler was clearly exhibiting a near singular focus on the partisanship of his districts.
Okay, well, let's change the question a little bit. I'm not asking you about any counties where there are districts drawn within a county. Okay, I'm asking,
A county drawn within the county.
I mean the district drawn within a county.
Okay.
Okay, so I'm not asking about those right now. I'm talking about districts that are formed by the whole county formula. Wasn't it clear that Dr. Hoffler's draft maps, he was drawing them under the constraints of the county grouping formula?
So I'm not quite sure about what you meant by your clarification at the beginning of your question. You're telling me that you're just trying to ask about the county groupings that only have one district, or what is it that you're trying to say?
Yeah, one district or two districts, but just based upon whole counties.
Okay, and you're asking me about the drawing of those county groupings?
Yeah, was he constrained by that aspect of the county grouping rule?
Well, sure. I mean, he was following the county groupings, and the county groupings include some districts that the county groupings include some groupings that just have one district. But if you look at the county groupings that have multiple districts, which we talked about quite a bit at length yesterday, you'll see that Dr. Hoffler was exhibiting a near singular focus on partisanship with those county groupings.
Okay, so so I got your answer there. Let's ask a different question. In the counties the county groups that had more than one district, but they have to be drawn, so one of the whole counties has got to be in the district under the traversal rule. Are you following me?
Sure, you're saying that in some county groupings, there are some whole counties that have to be kept whole.
Right. And did you check to see if Dr. Hoffler, in drawing his draft maps, felt constrained by the traversal rule in county groups where there were more than one district?
Oh yeah, I analyzed quite a few of those county groupings, and we talked quite a bit at length about them yesterday. And I looked through, and we talked about, and the court saw quite a few of these Excel files, which included all of these county groupings, many of which do have counties that are kept whole. And in those Excel files, we could still see that in almost all of the files that I found on these two folders called 2017 Redistricting and NC 27 Redistricting, almost every single one of those files exhibited or revealed a near singular focus on the partisanship of the districts.
Right. And
only a very small number of the files.
That wasn't really my question, Dr. Chan. My question was that, and we'll go through this later, and we will, but there are some districts where a county has got to be drawn into a district with population from another county under the traversal rule. If there's not enough population in a county to form a district, it's got to be kept whole and population added from another county. Isn't that true?
Sure, I agree with that.
And Dr. Hoffler's draft maps were constrained by that traversal rule.
Well, like I've already answered here, I'm realizing that Dr. Hoffler, I'm acknowledging that Dr. Hoffler is following the county groupings and following the whole county rule. So I've answered that.
Good.
Okay.
Now, did you check to see if Dr. Hoffler's draft maps were constrained by a goal to draw districts that were more compact in his drafts than how they'd been drawn in 2011?
If I could ask you to repeat your question.
Yeah, I mean, did you compare the compactness scores for the districts on Dr. Hoffler's drafts to the way the districts were drawn in 2011?
So I'm going to give you two answers that I think are both relevant to your question. I didn't specifically analyze the compactness scores, say the REOC or the Polsby-Popper scores of the draft districts in Dr. Hoffler's draft maps. So that's the first thing I wanted to say that I think is responsive. The second thing that I wanted to say that I think is also responsive is that I did analyze every single file in these two folders that are called 2017 redistricting and NC 2017 redistricting.
That's good.
And I only saw out of that very large number of files, many of which I wrote about and many of which in my report and many of which we talked about yesterday, I saw only a very small number that actually made any mention of anything other than partisan characteristics of the district. So there was a small number of files that had some statistics on, I think, on VTD splits and county splits. But aside from that, the vast majority of these files were Excel files where Dr. Hoffler was analyzing his draft districts, and the columns in those Excel files had nothing but a near singular focus on partisan characteristics and partisan incumbency characteristics.
Okay, I don't think that was responsive to my question, Dr. Chen. I just wanted to know, did you compare the compactness scores for Dr. Hoffler's draft plans versus the 2011 plan?
Right, and I gave you two answers that I think are both responsive. I told you that I did not calculate the Rioch and Polsby-Popper scores, and I told you that I looked through every one of these files, and I didn't see any mention of compactness.
Okay. Did you attempt to determine whether Dr. Hoffler's draft maps divided fewer municipal lines than the 2011 plan? That's, I think, a yes or no answer.
So same answer as before. I did not personally count up the number of split municipalities. I think that in those two folders I just mentioned, I found, I believe, one file out of many files in the 2017 and NC 2017 redistricting folders. I found, I think, one file that was basically an automatic report generated by Maptitude that made some mention or counting of municipal splits.
And the files you received were the ones that were given to you by the plaintiff's counsel and their vendor.
Well, the ones that we're just talking about here.
Is that a yes or no?
So I'm going to explain, I'm going to answer your question, Mr. Farr. The files that I'm just talking about here, I was given the entire contents of two folders. Those two folders were 2017 redistricting and NC 27 redistricting. It's my understanding that I was given the entire contents of those two folders. I looked at all the files on that folder. So it is my understanding that nobody went through and cherry-picked and decided which of those files to give me. I was given the entire contents of those folders.
And you weren't given any other folders to look at that might have had that information?
Well, there were other folders as well that I wrote about in other sections of my reports. Just wanted to clarify that. And we've talked about some of those Maptitude backup folders today as well.
Did you attempt to determine whether Dr. Hoffler's draft plans divided fewer VTDs than the 2011 plans?
Same answer as before. I did not personally go through Dr. Hoffler's draft maps and count up VTD splits. In the two folders that I just mentioned, the 2017 redistricting and NC 2017 redistricting folders, I believe I might have found one Maptitude report that counted up. And that was just one file, one of the very few files that did not exhibit a near singular focus on partisan characteristics of the districts that Dr. Hoffler was drafting up.
Okay, now yesterday, I've got a trial transcript where your counsel asked you a question I'm going to read into the record. And this is when you were, this is related to the part of your rebuttal report where you've got the county groups, where you're comparing the overlap between the Hoffler districts and the final districts. Do you remember that section of the report?
Sure.
And your counsel said, we just looked through a set of Senate county groupings. Is that the full set of all Senate county groupings that were redrawn in 2017 that have more than one district, meaning it's not just dictated entirely by the whole county rule? And you said yes. Do you remember that?
I mean, I'm happy to take your word for it.
Okay. And if, and you're free to look at your report if you want at this point in time, your rebuttal report, Dr. Chen. but I counted up 8 Senate county groups where you compared the population in Dr. Hoffler's drafts to the population in the final Senate map. Is that accurate?
I'm happy to count them up for you. You're just asking about Dr. Hoffler's draft Senate map, right?
Yeah,
And you want me to count up the number of groupings that I analyzed?
yes.
Sure, I'll go ahead and count that up here, so if you'll just give me a moment. Okay, I think I counted 8 county groupings.
Okay, so of the 27 county groups in the Senate, 21 of those groups found their way into the final enacted plan because of the county grouping rule. Is that a fair statement?
No, I don't know what the basis of you saying that is.
Well, your counsel said that those 8 maps, I'll just repeat it, the full set of all Senate county groupings that were redrawn in 2017 that have more than one district, meaning it's not just divided entirely by the whole county rule, dictated entirely by the whole county rule.
Okay, so you're just saying 28 minus 7.
Right.
Or sorry, 20 minus 8, right?
I think it's 27 minus 8 gets to 21.
If you want me to get out my report where I've listed out all the county groupings, maybe I can give you an accurate answer.
That's why I went to law school.
All right. So what I'll do here
So
is,
it's 19. Right? Do I pass this?
if you'd
time?
like me to, I only want to do this if you want me to take up your time doing this. I'll get out my report, my original report, where I've listed out all the Senate county groupings, and I'll give you an accurate number.
Well, is 27 the correct number of county groups? Okay, what is it? I'll take your representation.
Well, if you want me to answer it, I'm going to need to get out my report.
You go ahead and look then, Dr. Chen.
All right, I'm going to get out my report.
Good.
To speed this along, Dr. Chen, which is on page 15 of your report.
And please check on the number of House county groups while you're doing that, Dr. Chen.
Okay, we can do that in a moment. I'll do this one first. So I've listed on this page 29 county groupings.
So 29 minus 8 equals 21. Am I right?
I can affirm your math there.
Okay. Now, how many House groups are there?
I have here 41 House county groupings.
Okay, and then can you count up how many of the county grouping maps that you studied in your rebuttal report to compare the overlap between the Hoffler drafts and the final plan?
Okay, you want me to count that one up?
Yes.
All right. believe I just counted 16.
Okay, so if 41 minus 16 is how much, Dr. Chen? Since I get it wrong too many times, what does that come up to?
All right, 41, and I'm just telling you about your math, the math question that you just asked. 41
Right.
minus 16 is 25.
Okay. Now let's turn to your rebuttal report. And I want to start with, it's, I think Plaintiff's Exhibit 125, but it's Figure 2 in your rebuttal report. Are you there?
Yes, I am.
And before I ask, I want to go back and one follow-up question to finish up the county group rule. When you did your calculations of overlap of the census blocks and the population.
Sorry, I lost you. Could you start the question?
Sure. Thank you for asking me, Madam Court Reporter. When you did your study of the overlap it was, between the population and the census blocks, between Dr. Hoffler's drafts and the enacted plans, you did a statewide comparison.
Well, I did a district by district comparison. I did that for all the districts on the map.
And then you added it up to have a statewide comparison.
After doing the district by district numbers, I aggregated the numbers up to report one statewide number that I reported early on in my report.
And included in that statewide number was population that came from districts that were drawn exclusively by the whole county rule.
Well, sure, there are some districts that are affected by the whole county rule in the sense that there is one district in that county grouping. There also are a lot of county groupings that have multiple districts, and even within those, I found that there was a very high degree of overlap in terms of the district boundaries in those districts, even the ones within just a single county.
We'll get to that, Dr. Chen, but in your statewide calculations, you included in your comparison population carried over in districts formed by the whole county rule, which Dr. Hoffler had no discretion not to follow.
Well, like I said, I included every single district in Dr.
Okay.
Hoffler's draft plan.
All right, now let's go to 125, which is plaintiff's 125, which is figure 2 in the rebuttal report. And I may not get this exactly right, but your counsel, I think, asked you about this group, and he correctly asked you, I think, that, for example, the whole county provision doesn't dictate how Surrey County is divided up. Is that a fair statement of what he asked you?
I'll take your word for it.
Okay. Now, he didn't ask you about Allegheny or Alexander County, did he?
I just don't remember.
Okay, well, Allegheny and Alexander counties are wholly included in the district, are they not?
I mean, I can see that Allegheny and, what was the other one that you said?
I think it's Alexander.
Sure, yeah, you can, but if we could just zoom out on the entire, the county grouping here, you can see that the district lines within Rockingham, the district lines within Surrey, they're not somehow dictated by the whole county rule. And you can see that the district lines within Rockingham County are exactly the same in Dr. Hoffler's version and the final General Assembly's.
Okay, and I didn't ask you that question, Dr. Chan. I'm just asking you, and I agree about the lines in Surrey County and Rockingham, and I'm not going to question your testimony on that you gave yesterday. But what I am going to ask you about is Allegheny and Alexander are counties that are wholly included in a district. Is that correct?
And I just answered that. I said,
Yes.
yes, they certainly are.
And that's required by the traversal rule, is it not?
Well, the county traversals rule requires the minimization of county traversals. I don't know if you could possibly get away with still splitting up Allegheny and still minimizing county traversals. It's not something I try to analyze. So that's the extent to which I can answer your question.
Okay. But if there's a case that says that if a county lacks sufficient population for a district, it has to be kept wholly in a district. Would that not mean that Dr. Hoffman would be constrained by the traversal rule and would have to put Allegheny and Alexander in a district without dividing them?
Your Honor, if I could just object, I'm not sure that's a correct statement. If the law council wants to pose it as a hypothetical, that's fine.
I'll just rephrase my question.
If you understand that as a hypothetical,
I'll withdraw it.
Yes,
I'll
sir, go ahead,
withdraw it,
Mr.
Your
Farr.
Honor. Okay. Allegheny and Alexander are wholly included in districts, are they not?
I see that.
And your counsel didn't ask you any questions about those counties when he cross-examined you on this figure.
I don't remember, but I'll take your word for it.
Okay. And you included the population in Alexander and Allegheny in the statewide comparisons you made, determining the overlap between Dr. Hoffler's plan and the final enacted plan.
Yes, of course I did. And that's
Okay.
because the map drawer still has discretion in, let's say, what parts of the surrounding counties that are split up to combine with Allegheny counties. That's why you still analyze every single district here in this grouping, because there's still a decision to be made about where to combine the whole counties. Say Stokes County, which is going to be kept entirely within a single district, but you've got to combine it with a split portion of Rockingham County. So you've got to analyze all of these districts, even if the district includes a county that is going to be purely within a single district. It wouldn't make sense just to ignore that. And if you can look at the district boundaries within Rockingham, you can see that the way that Dr. Hoffler combined Stokes with the western portion of Rockingham in his draft map is exactly the same way as we see in the final House Bill 927 version of those districts.
So you think Dr. Hoffler had discretion to divide Allegheny and Alexander into different districts? Is that what you're saying?
That's not what I just said.
Okay. Let's just do one more of these figures to make sure I understand your testimony, because we'll have the same questions for all these figures, and I don't think I need to go through all of them, but let's look at figure 6, or figure 4, which is Exhibit 127. And that's your map of the Caswell Orange group. Do you see that?
Well, that's Dr. Hoffler's plan. It's
Okay.
not really my plan.
Right. I got you. I'm sorry. And you can see that Caswell's wholly included in District 50.
Yeah, I can see that Caswell is not split up. It's Orange County. I mean, the grouping is just set up in a way that Orange County has got to be the county that's split up into two districts.
And did Dr. Hoffler have any discretion under North Carolina law to divide Caswell County instead of Orange County?
Well, obviously, by virtue of its population, Caswell has got to be kept wholly within a single district. What the discretion is over is what portion of Orange County to combine with Caswell County into District 50. That's where Dr. Hoffler's got discretion, and we can see that the way that he drew that district boundary was virtually the same as what we saw in the final General Assembly's House Bill 927 version of these districts.
Okay, and so that's good, Dr. Chen. Thank you for that clarification. And just to make this point clear, when you did your statewide comparison between Dr. Hoffler's drafts and the enacted plans, you included Caswell County population, right?
And again, I included every single district.
Okay. Now, let's turn to figure 7. This was Plaintiff's Exhibit 130. I don't remember you testifying about this yesterday. I could be wrong, but this is the Duplin-Onslow County group. Do you see that?
Yes, sir.
And Dr. Chen, do you know that District 14 and District 15 were carried over from the 2011 plan?
Yes, sir.
And so, do you know if Dr. Hoffler has any legal authority under the North Carolina Constitution to change those districts?
I'm obviously not going to be able to give you a legal answer to that.
Okay. And there's only 3 districts in that plan, right? In that group.
Yes, I see that.
And if Dr. Hoffler, let's just hypothetically speaking, if Dr. Hoffler was obligated to keep District 14 and 15 because of a state constitutional requirement, you'd have to draw District 4 the way it's drawn, correct?
Well, I just have no basis for what you're asking me to know about the legal conclusion that you're asking me to accept. I mean, I can abstractly tell you that certainly if you got a county grouping with 3 districts and you've already drawn 2 of them, then the 3rd one is predetermined. Beyond that, I'm really not going to be able to give you a legal opinion about what you're
Well,
asking.
I didn't ask you for a
Sure,
legal
but I
opinion.
think I've answered your question.
I think you have. Thank you. And Dr. Chen, just to get this out of the way, do you know what county group House District 14 and 15 were in under the 2011 plan?
I'm happy to take your word for it if you want to just tell me.
Well, I don't know either, to be honest with you. But I want to know if you did.
I didn't want to waste your time by looking it up and.
Well, let me ask you this question. Whatever county group that 14 and 15 were in 2011, did you do simulation plans that could determine the political index for the districts in 2011?
I just don't know what you mean by that question. Political index?
Well,
What are you saying?
Dr. Chen, you've talked a lot about, I think it's 47.92 is the vote share that you calculated for the 2010 to 2016 composite that you used when you were predicting Democratic and Republican districts.
You're talking about my testimony yesterday, right?
Yeah.
Okay, I think what you're trying to refer to is that if you take those 10 statewide elections that Representative David Lewis said that the redistricting committee was going to use
Right.
in measuring district partisanship, you'll find that it produces, that his elections produce a 47.92% Democratic vote share.
Right, and did you attempt to run any simulations to determine the partisan leaning of House District 14 and 15 and any other districts that were in the same county group in 2011?
Your question really just doesn't make sense to me. I don't run simulations to measure the partisanship of any enacted or existing planned districts.
Oh.
I run simulations in order to produce another baseline of computer simulated maps that are completely different from, that are completely independent from the enacted House plan
All right,
districts.
okay. Did you do any simulations for the 2011 plan?
Like I'm saying, the question just doesn't make sense to me. I don't do simulations of enacted House plans, including the 2011 House plan.
Did you draw simulated maps using the county groups that were used in 2011?
Okay, I see what you're asking. And the answer is I used the 2017 county groupings only.
Okay. All right, Dr. Chen, I'm done with asking you about Dr. Hoffler. So I'm going to move to some different questions. These are just a few questions about your experience. You've never produced a districting plan intentionally for the purpose of proposing it to a legislature for adoption.
Not for proposing to a legislature for adoption.
And you've never been hired by a redistricting commission to produce a legislative plan.
No.
You've never been hired to advise members of the legislature on the process that leads up to a majority of the members in the legislature voting to enact a redistricting plan.
Not in any formal way.
And you've never studied how members of a legislature vote for redistricting plans based upon their partisan affiliation.
I've studied legislative behavior generally, but not that particular form of legislative behavior.
Okay. Now, I want to ask a few questions about your experience on simulated plans. You started working on simulated plans when you were in grad school from 2004 to 2009.
That sounds right.
Currently, redistricting is the focus of your academic research.
Yeah, I think that's fairly safe to say.
Most of your academic research deals with simulated plans.
I would say a lot of it does.
And you have not done a comprehensive catalog of traditional districting principles used in all 50 states.
I've studied traditional districting principles in a lot of different states. I'm not sure that all 50 is an accurate description, but I've certainly looked at traditional districting principles, looking at state constitutions, state statutes, looking at how principles are applied in a lot of different states.
But you've never done an explanation of here's all the districting principles used in every state in the United States.
Like I said, I've done that for a lot of states. I'm not sure for all 50 states.
Okay. And you've used geographic data to produce simulated plans for all 50 states.
I think you're talking about geographic information systems data, is what you're trying to say. And I think I've done so for at least 49 states and possibly all 50 states.
Okay. Now, in this case, Dr. Chin, you started working in December of 2018?
I don't remember the precise time, but I think that's roughly the right ballpark.
And you finished in late February or early March?
I think my first report was April the 8th. So that was when I finished writing the report.
Okay. Now, the legislature did not have the benefit of your report at the time it enacted the 2017 plans.
Well, obviously I didn't write the report until April the 8th.
So, people that draw maps often use Maptitude to draw maps. Is that a fair statement?
I would say it is it is one software that is used. I don't know exactly how often it is used versus another system versus other software systems. There's lots of different map drawing softwares out there.
Okay. So without a map, if you didn't have an algorithm and you had a map drawing software like Maptitude, how long do you think it would take someone to draw 4 sets of 1,000 plans to compare?
Never try to answer your question.
Do you think it would take them a lot longer than the amount of time that you spent on this case?
Like I said, I've never tried to answer that question.
Think it'd be plausible that it'd take them a lot longer if they didn't have an algorithm?
Like I said, I really just have no basis.
Now, in your deposition, I asked you whether or not a map drawer who said they were adhering to nonpartisan criteria could actually be doing that with partisan intent. And you told me that that was theoretically possible. Do you agree with that?
If you want to just put the transcript in front of me,
Sure.
I think maybe that'd make it a little clearer.
Sure. Can you hand up the depositions?
Is it in the binder that you gave me here?
No.
Okay.
do is just use this to refresh your memory instead of reading into the record, although we can do it if you want to. But if you could just look at, I asked you a question on page 93, page 5, and if you would read to 94, page 20, and just tell me if that refreshes your recollection.
Okay, you just want me to read this silently?
Let's try it that way first, because it's a lot of text, and I don't want to.
Okay, and you said from the middle of page 93, is that right?
I asked you a question on line 5 of 93, and then you kind of give an answer that goes on until page 94, line 20.
Okay, so you want me to read to line 20 on page 94?
Yeah, just to at this point, just to yourself. I'm just trying to
Okay.
refresh your recollection.
All right, sure. Okay, I think I've finished reading what you asked me to read.
Okay, so is it theoretically possible for a map drawer to use traditional redistricting principles when it benefits their party?
Sure, and I'm going to make reference to the answer that I gave you in my deposition testimony.
Please do so.
The way that you asked me the question was with respect to a specific criterion of maximizing compactness and whether that could be applied in a partisan way. And what I told you, and I apologize for being really long-winded at deposition and taking a page and a half to get to the point, but what I told you was that the question just made no sense to me. And that I guess theoretically it could be possible that a map drawer could say, follow maximizing compactness, but only in those districts, only doing it in a selective way in those districts where compact districts were beneficial to that map drawer's party or to the map drawer's partisan goals, but then not follow compactness when it was not convenient to do so for the map drawer's party, something along those lines. And I told you that that just seemed like a really strange kind of hypothetical question. It didn't really make much sense to me, but that was the best I could kind of engage with your really odd question. So that's what I told you. And again, I apologize for taking about 2 pages in the deposition transcript to get there, but I stand by that answer.
Okay. Thanks, Dr. Chen. I don't mean to ask odd questions. Now, Dr. Chen, your simulated maps that you testified about, is it fair to say that they are all better for Democrat candidates than the 2017 enacted plans?
So for every set of simulations where I'm comparing it to the enacted House plan or the enacted Senate plan, whatever the corresponding enacted plan was, what I found was that the number of Democratic districts of the enacted plan, in the enacted plan, was always an extreme partisan outlier. It was always lower than the number of Democratic districts across the 1,000 simulated plans for each of the simulation sets that I testified about yesterday.
Okay. And so if the legislature or this court adopted one of your simulated maps, they would know that it was better for Democrats than the 2017 enacted plans.
Well, I mean, I don't know what you mean by adopt. If the court adopted one of these plans. I'm not sure exactly what that means, but I mean, I've told you that all 1,000 of these plans have a number of Democratic seats that is different from the number of Democratic seats in the enacted House and Senate plans. And the enacted House and Senate plans are always lower. They're always extreme partisan outliers.
Okay. So the answer is if whoever was deciding on the map adopted one of your simulated plans, it'd be better for Democrats than the enacted plan.
If you just picked any one of those maps at random, any one of those 1,000 or 4,000 computer simulated maps, you would find that in that simulated plan, that computer simulated plan, has more Democratic districts than the enacted plan.
Okay. Now, Dr. Chen, could you turn to tab 1 of your notebook? It's Legislative Defendants Trial Exhibit 244. This is the witness notebook that I gave you. Do you have that, Dr. Chen?
Yes, sir.
And so this is the exhibit, Legislative Defendants Exhibit 244. Could you turn to page, well, first of all, let me ask you what this is. This is your expert report that you gave in the Common Cause v. Rucho case?
It appears to be that.
Okay. Could you turn to page 12?
Okay.
Okay, so looking at page 12, Dr. Chen, is it fair to say that in this report you did 3 sets of simulated plans?
Yes, I did.
Okay, and your first 2 sets of simulated plans always divided, these are simulated plans for congressional districts, to make that clear, right?
Yes.
And your simulated plans were always able to divide no more than 12 counties.
That's what I report on the 3rd and 4th columns of the number of split counties row there.
Okay.
So 12 county splits.
And the enacted plan in 2016 divided 13 counties.
I see that.
And you ran a 3rd set of simulations dividing 13 counties. Is that correct?
Your Honor, if I could pose an objection. Yesterday, legislative defendants objected when we were questioning Senator Blue, or maybe it was Monday at this point, when we were questioning Senator Blue about the 2016 congressional plan and districting of that plan. The objection was sustained, I believe, on relevant grounds. So if we can't ask questions about the 2016 plans and process, it seems that they should not be allowed to do that.
Your Honor, I don't remember that. I thought they got up and said that it was the same people drawing the plans and that was all relevant evidence. And this relates directly to the test that Dr. Chen has performed in this plan. So, Your Honor, at a minimum, I'd ask that you would reserve your objection on this until you hear more testimony.
Well, there was an objection raised by you, I believe, Mr. Farr, to testimony by Senator Blue about what Representative Lewis may have said about the 2016 congressional plan that you objected to on the basis of hearsay and relevancy.
I thought, first of all, Your Honor, I'll accept your representation. It wasn't me, it was, I think, Ms. McKnight. But I thought the objection was legislative privilege.
No, sir, it was hearsay and relevancy.
Okay, well, he's here, so he's being examined, and he can confirm what he's done in his report. And I would just ask that you wait and hear how this plays out.
Briefly, Your Honor, for hearsay purposes, it's still hearsay, but it's the witness's prior statement. And if I'm I mean, relevance obviously is the same relevance, right?
It may be, it's possible that what you're seeking to offer this for is for impeachment or credibility purposes. I don't know if that's the reason, but there are purposes that it could be admissible. I think we'll allow the line of questioning. I'll just caution you, it may open the door to the relevancy of 2016 congressional map drawing, depending on where you're going with this. So we'll just
Okay.
make that note. Go ahead,
Thank you,
sir.
Your Honor. So, getting back to this report, Dr. Chen, even though you're in set 1 and 2, your simulations divided only 12 counties, you ran a third set that divided 13 counties because the enacted congressional plan divided 13 counties. Is that correct?
Well, that's not quite correct. What I wanted to do, as I explained in detail in the text of this report in the congressional case, is I wanted to determine whether an intentional effort to split 13 counties, whether, say, the General Assembly's hypothetical intentional effort to split exactly 13 counties and to protect exactly 11 incumbents could possibly explain the extreme partisan bias of the final SB2 plan.
Okay, that's what I was going to ask you, so thank you. Now, Dr. Chen, could you just turn to, I think it's tab 2, or Exhibit 155. We've looked at this before. I'm not going to go belabor it. But will you again confirm that this was the adopted criteria that the General Assembly put in place for the 2007 House and Senate plans?
You're on Exhibit 4 now?
Yeah.
Okay, yes.
Is that it?
Yes.
Okay. Now, yesterday you just tried to describe your algorithm and how it worked with compactness, fewer split precincts and municipal boundaries. And I think what you said for compactness was all other things being equal, the algorithm preferred more compact districts to less compact.
Exactly.
And is that the criteria, is that the way the criteria is stated in Exhibit 155?
I'm telling you that that's how I interpret this sentence here, improve the compactness of the current districts. And so when I see those words there, I interpret it as meaning the statement that, or I program that in my algorithm as saying more compact districts are preferred over less compact districts. I don't know of any jurisdiction in the country that actually says we want less compact districts, and that's better than drawing more compact districts.
Okay. Do you know any other jurisdiction that's adopted your definition, that all other things being equal, more compact or favored over less compact?
It's not a definition. I see the words improve the compactness, and I'm telling you that's what it means when I'm actually programming the algorithm.
Okay, that's how you interpreted it.
It's not really, sure, I mean, that's fine if you want to call it an interpretation. I'm just telling you that I read these words here, the adopted criteria, and when I see words like improve the compactness, that's what I read it to mean. Because I don't know of any jurisdiction in the country that says we actually like really badly non-compact districts. And that's actually a good thing. And don't make the districts too compact. You can make districts sort of compact, but don't make them too compact. That just wouldn't really make sense.
Okay, but you haven't cited any other jurisdiction that adopted your definition of compactness. This is the way you interpreted this criteria.
Well, look, the way that I program my simulations, including the part with respect to compactness, that's based on my expertise.
Okay, and you see where it says fewer split precincts?
Sure.
Your testimony was all other things being equal, the algorithm preferred fewer divided BTDs or precincts.
Yeah.
Is that what that criteria says?
Well, the criterion says split fewer precincts. And when I see those words, split fewer precincts, I interpret that and I apply that in my algorithm as meaning that districting lines that split fewer precincts are preferred over ones that split more precincts. I mean, that's just what those words mean to me. It's pretty clear what is being expressed here. I don't know of any jurisdiction in the country, again, that actually says we actually really, really want more split precincts. And don't try and get the number of split precincts down too low. We really like more split precincts. That just would make no sense.
Well, it doesn't say they want more split precincts, does it, Dr. Chan?
No, and that's exactly why I apply the algorithm. I apply this criterion in my algorithm to say that districting lines that split fewer precincts are preferred over districting lines that split more precincts.
Okay, so
Oh,
then.
sorry, I mean, I should be saying VTDs, but I think we explained that. I explained that distinction yesterday.
Yes, sir. This is a very experienced court that we're fortunate to have, and they have a lot of background on BTDs and precincts in North Carolina. So looking at the municipal boundaries criteria, you testified that all other things being equal, fewer divided cities were preferred over divided cities. And is that what that criteria says?
Well, the criterion says may consider municipal boundaries. And when I see those words, consider municipal boundaries, I interpret that as meaning that districting plans that split fewer municipalities are preferred over districting lines that split more municipalities. Same reasoning as before. I just don't know of any jurisdiction in the country that actually says we like splitting a certain number of municipalities at a minimum.
Okay, you've never had a chance to talk to Representative Lewis or Senator Heiss about what they meant by that criteria, have you?
I've not personally talked to them.
Okay, so let's see what they said about it. Let's turn to exhibit under tab 3, exhibit 103. And Dr. Shin, can you see that?
Mr. Farr, I don't know if I'm missing something here, but I'm flipping to tab 3, and it appears to have, this transcript appears to skip from page 17 and skips all the way to page 128. Am I missing something?
You are. Can we call it up on the screen?
Is there another copy you could just give me? I'd be happy to.
Your Honor, is your version?
Ours is the same as the testifying witness.
I apologize, Your Honor.
Your Honor, if I could, I don't know if this will short circuit or not, interpost objection. The line of questions that I think we're about to hear is about Representative Lewis's intent and how he meant this criteria to apply. This is covered by the court's sword shield ruling. Obviously, this is specifically about the intent of one of the people who asserted legislative privilege. We weren't allowed to depose. If we were allowed to depose him, we would have asked him questions about exactly these sorts of things. So to the extent, I don't know any other purpose for which these questions could be asked other than to try to show Representative Lewis's intent.
Your Honor, that is a mystifying objection to me. This is part of the public record. It's an official transcript. I have never heard of a North Carolina case where legislatures have regularly exercised legislative privilege, but that does not mean that the court can't consider transcribed proceedings and statements by the legislatures during the course of the debate over the legislation.
I recall from our hearing several months ago relating to Sword and Shield and the discovery consequences that had with respect to legislative privilege, that the plaintiffs stated that they were content to rely on what was in the public record regarding intent. I'm not sure that we understood, and I'm not speaking for the other two judges because we haven't conferred, that you were intending that there could be no evidence of intent of the legislature, but rather that there could be no elaboration of intent of the legislature that was not contained in the transcript. Did I misunderstand that?
I understand what you're saying, Your Honor. I'll withdraw.
You know, I think that the plain meaning of what an official public record of the General Assembly says, that can be put into the record, but as to elaboration of that or speculation by any witness, that may well be within the parameters of the sword and shield doctrine that we confirmed in the motion in limine ruling the other day.
If I could just clarify, Your Honor, and maybe it's just because I know the questions that are about to be asked because they were asked at the deposition. To the extent the questions are going to be counsel's interpretation of Representative Lewis's intent and his, which is, I think, a disputed issue here, that's my objection to that, is sort of presupposing what Representative Lewis meant when he said a certain thing.
Your Honor, I just find that mystifying. I'm just going to have him read what Representative Lewis said, and then I'm allowed to argue whatever I want to argue based upon the evidence that's in front of the court.
Yeah. All right, we're going to overrule the objection that, as we confirmed, I'm not sure, yes, I believe we had filed actually the order, but we confirmed in the order that we filed that the sword and shield doctrine, that motion in limine applies, and that the public record would be accepted, and that is what will be considered by the court, not any elaboration of the legislative intent by legislatures who asserted legislative immunity. So you may proceed.
We have no intention to call Representative Lewis, whose statement we're going to go over right now. So we understand the scope of your order.
All right. Yes, sir. Do we have a complete copy? Oh, you're publishing it on the screen. Is that the intention?
Yes, Your Honor, and I apologize. I think we took this out of the notebook because it's one of plaintiff's exhibits, and we were trying to limit the amount of paper that the court had. So I apologize. I didn't know that we had done that.
Yes, sir. Go ahead.
Because they don't trust me with important stuff like that.
Mr. Farr, I just wanted to request that if you're going to have me read from the transcript, I'd prefer to have a copy in front of me if that's at all possible.
Your Honor, may I clarify for a moment?
Yes.
Dr. Chen, you should have the excerpted pages that Mr. Farr is going to turn your attention to under tab 3, I believe, unless there was a ear-breaking error. We were just trying not to put the full 128-page transcript in front of you to avoid massive binders. If Mr. Farr turns your attention to a page that you do not have, we're more than happy to get you a copy.
May I approach the witness, Your Honor, and just see?
Yes.
Dr. Chen, I apologize.
I had understood Mr. Farr to ask me to turn to page 102. That's when I noticed that there was no page 102.
Yeah, well, that's because Mr. Farr didn't enunciate correctly. So I think that the questions I'm going to ask you are on pages that are in this exhibit.
Okay, sure.
And I apologize to the court. So thank you, Dr. Chen. So you're now at Exhibit 103. And let's first of all identify this.
Mr. Farr, did you mean to say Exhibit 013?
013, thanks.
Okay.
This is a transcript of a proceeding before the House Committee on Redistricting on August 25th, 2017. Is that correct?
Yes, sir.
All right. And Dr. Chen, could you just first of all turn to page 5, line 8. And does that appear to be at the beginning of a transcription of a statement by Representative Lewis.
Yes, sir.
Okay, now I want you to turn to page, we're going to start reading some things on page 11, but I just want you to satisfy yourself that when we start on page 11, that's still Representative Lewis speaking.
Okay.
So the first thing I want you to read, Dr. Chin, is Representative Lewis's statement on compactness, which begins on page 11, line 19, running through page 12 on line 21. And if you could just read that into the record, I'd appreciate it.
Okay, you want me to read from 19 to 21?
19 on page 11 to 21 on page 12.
Okay, you want me to read that entire roughly one page?
Yes, because I think you probably read better than I do, so if you would do that, I'd appreciate it.
All right. Compactness. The committees shall make reasonable effort to draw legislative districts in the 2017 House and Senate plan that improve the compactness of the current districts. In doing so, the committee may use, as a guide, the REOC dispersion and the Pulsby-Popper scores as identified by the people that invented that particular score, those particular scores. I would point out that the map that I present to you today complies with that criteria. The criteria minimum for REOC is 0.15. The minimum compactness found in this plan for REOC is 0.2. The maximum is 0.7. The mean is 0.41, and the standard deviation is 0.09. I say all that to say that we were able to comply with this committee's criteria in regard to the REOC score. In regard to the Pulsby-Popper score, the minimum criteria is 0.05. Excuse me, yes, the criteria minimum is 0.05. The minimum district on this plan is at 0.2. The maximum is at 0.71. The mean is 0.31, and the standard deviation is 0.11. I say all that to say again that based on the compactness criteria defined in the Pulsby-Popper test, this map is compact. I'll be happy to go into greater detail on compactness. I will simply say that based on and I will submit this for the record, based on a comparison of reports with prior enacted plans, this is a compact plan.
Okay, and Dr. Shin, nowhere by the way, did your counsel provide this transcript to you when you were working on this case?
I don't remember.
Do you recall reading this before?
I may have. I don't recall if you put it in front of me at your deposition of me. I just don't remember.
Yes. In all candor, Dr. Chen, I think I did ask you at the deposition, so I apologize for not saying that. Nowhere in here does Representative Lewis say that all things being equal, more compact districts are preferred over less compact districts, does he?
Well, the point of what Representative Lewis just says is improve the compactness. And we know what that means. Representative Lewis, in the section that I just read, it's really notable and it's just logical. Representative Lewis did not say there is a maximum level of compactness that he did not want to go above. He did not say, for example, that a REOC score of 0.6 is just too high, it's too compact. We want less compact districts. That would just be absurd. And of course he didn't say that, because what Representative Lewis actually read from the adopted criteria, it says improve the compactness of the current districts. And when you see words like that, you know what that means. I interpret that at least to mean that district lines that produce more compact districts are preferred over district lines that produce less compact districts. It's really telling here that even though Representative Lewis offers his idea or his perhaps interpretation of a so-called minimum REOC score, he does not offer us a maximum REOC score. He tells us that he thinks that the minimum for REOC should be 0.15. He does not tell us that the maximum for REOC should be, say, 0.35 and that he doesn't want to go above 0.35. Why? Because that logically just makes no sense. Nobody thinks that well, and no jurisdiction in the country would say a district is just too compact. We want less compact districts.
Okay, and you haven't identified any jurisdictions that would say that? Any specific jurisdictions in your report?
That say what?
What you just said.
Oh, sure. I didn't type all of that out into my report. I was using my expertise, which I just tried to explain to you, but I certainly did not lay all of that out exactly as I just laid out. I just simply relied upon my expertise, and I said I was relying upon my expertise.
But based upon your report and your testimony today, you haven't identified any jurisdiction that would follow your understanding of compactness.
I'm testifying that this is how I understand the traditional districting criterion of compactness, and lots of jurisdictions actually have a compactness requirement or a compactness criterion. And I'm testifying that when I see that sort of compactness criterion, we know what that means. It means that district lines that produce more compact districts are produced over districting plans that produce less compact districts.
But you haven't named any of those jurisdictions in your report. Yes or no?
That wasn't the point of my report, so of course I didn't do that.
Okay.
I relied upon my expertise as a
Okay.
redistricting expert, which includes what I just described.
Okay. Now, let's go to his next statement about criteria. Please read, this involves fewer split precincts. Start on page 12, line 22. And read until page 13, line 15.
Okay, so you want me to read that almost one page there into the record?
Yeah.
All right.
12:22 to 13:15.
Okay. I'm going to get some water before I start reading this.
Please do so.
One of the committee's goals was to have fewer split precincts. The total number of split precincts, or split VTDs, in this plan, as drawn, is 19. It's important to point out that there are 49 total splits, but those additional splits between 19 and 49 occur in areas of the plan that were not impacted by the regrouping, the new county optimization formula. What that means is, what we drew splits only 19 precincts. If you compare that with the 2011 plan, the Lewis Dollar Dockham 4 plan, there were 395 split precincts. The 2009 House plan split 285. 2001 House plan, as best we can tell, split 103. I would point out for the record, in total transparency, there is one additional split VTD in Cumberland County. It's on the base, the Army base. There are no people that live there. It makes the map look more compact.
Okay, thank you, Dr. Chen. And now I would like for you to read Representative Lewis' statement about municipal boundaries, which starts at 13, line 16, and runs through line 24.
And I'm sorry, Mr. Farr, if you could just repeat those lines
Sure.
again.
I'm sorry, Dr. Chen. I think Representative Lewis' statement about the municipal boundary criteria starts on page 13, line 16, and runs through line 24. Could you read that, please?
Okay, so that's roughly 10 or 8 lines that you just want me to read in the record?
Yes.
All right. We wanted to respect municipal boundaries. The committee adopted the criteria of municipal boundaries. We said that we may consider municipal boundaries when drawing legislative districts in 2017 House and Senate plan. Again, I think this plan meets that goal. The 2009 plan split 123 municipalities. The 2011 plan, Lewis Dollar Dockham, split 144. This plan split 78.
Okay, thank you. And the one final part of this I'd like for you to read, Dr. Chen, is Representative Lewis about the incumbency protection criteria, which begins on page 13, line 25, and runs through page 14, line 11. Could you please read that?
An additional criteria that was adopted by this committee is incumbency protection. It reads, quote, reasonable efforts and political considerations may be used to avoid pairing incumbent members of the House or Senate with another incumbent in legislative districts drawn in the 2017 House and Senate plans. The committee may make reasonable efforts to ensure voters have a reasonable opportunity to elect non-paired incumbents of either party to a district in the 2017 House and Senate plans, end quote. Again, this plan meets that criteria.
Okay, thank you. I'm done with that exhibit, Dr. Chen. Now I'd like for you to turn to, I believe it's tab 4, Legislative Defendants Exhibit 159. I'm sorry, it's tab 5, Dr. Chen. I have to have some help down here. So, Dr. Chen, do you recognize this as the Special Master's recommended plan for the North Carolina Senate and House of Representatives that was filed in the Covington case?
I do see that.
Okay. And it's fair to say that in that case, the court directed the special master to draw 4 districts that were enacted in 2017 that the court concluded too closely aligned with illegal majority black districts in 2011.
Objection, if the council wants to pose that as a representation or hypothetical, that's fine, but the witness obviously doesn't know what the court concluded.
Mr. Farr?
Well, can we look through this, Dr. Chen? And you talked about the frozen districts in your report. Is it not fair to say that the special master redrew Senate District 21, 28?
If Mr. Farr, if you're going to read out a list, I'd rather get out my report and then I can tell you what I know and what I don't know.
Okay, that's fine.
All right, so I'm going to get out my original report and then you can go ahead and read out your list. And if you're going to, are you going to go ahead and read that list out to me?
If that'll help you. I mean, my
Okay.
understanding is that the special master changed Senate District 21, 28, and House District 21 and 58.
That's not my understanding with respect to 58.
Oh, okay. Did he change? What's your understanding about Guilford County?
My understanding is that the special master was tasked with withdrawing HD 57, and that I've written that on page 18 of my original report.
Okay. I won't question that for the moment. Can you turn to page 4 of Exhibit 159?
Okay.
You see at the top of that page, it says principles guiding the plan.
Yes.
And you see there's a section that says court ordered.
I see that section.
Okay. Can you just read into the record the bullet points that are under the section labeled court ordered?
You want me to read that entire section?
Yes, into the record, please.
Okay, sure. Only redraw districts adjoining, quote, subject, end quote, districts. Adhere to the county groupings of the 2017 plan. Quote, make reasonable efforts to follow state policy objectives, end quote. Keep precincts whole. Split fewer precincts than the 2011 enacted districts. Compactness. Draw districts that are more compact than the 2011 enacted districts, using as a guide the minimum REOC dispersion and Polsby-Popper perimeter scores. Consider municipal boundaries and precinct lines.
And then there's a section called prohibited, correct?
Yes.
And could you read those also?
Consideration of election results. Incumbency beyond unpairing after the fact.
So under the principles guiding the special master's plan, the special master was told he could not consider election results. Is that a fair statement?
I'm happy to take your word for it. I'm just reading off of this page. I can't tell you exactly what directions the court gave to the special master.
Okay. Now, Dr. Chen, in your report, you don't make the argument that the 2007 plans violated the state's county grouping rule.
If I could ask you to repeat.
You don't contend in this case that the 2017 plans violate North Carolina's county grouping rule.
I didn't analyze that in any empirical sense, and I think your question is calling for a legal judgment, which I'm obviously not going to have an opinion about.
Okay. But you, in your simulated maps, you use the same county groups that are found in the enacted plans.
I did use the same county groupings.
And in your report, you did not contend that the 2017 plans violated North Carolina's traversal rule for districts drawn within a multi-county group.
Same answer there. That's a legal question. I'm obviously not going to give you a legal opinion.
Do I recall that you used the same number of traversals that were found in the enacted plans?
I didn't use the same number of traversals. What I testified yesterday is that I did count up the number of traversals that emerged in all of the computer simulated plans and the enacted plans, and I found that they were the same.
Okay. And you've done two sets of plans, 2 sets of 1,000 plans for the House and 2 sets of 1,000 plans for the Senate.
Exactly.
And the difference between set 1 for both the House and the Senate and set 2 for the House and the Senate is your incumbency protection element that you've explained.
Yeah, and we talked about the different elements of that yesterday, but it was all under various ways that I was building incumbency into the simulation algorithm.
And you did not follow the General Assembly's criteria for incumbency protection.
That is not a correct statement.
Didn't their criteria say that when possible that they would put incumbents in districts where the voters would have a chance to reelect them?
Look, obviously, the adopted criteria says more than just that. If you want to put the adopted criteria out in front of me, I'd be happy to go through it, and we'll talk about what I did and did not do, but obviously that's not the entirety of that section.
Okay. Now let's turn to tab 6. Your Honor, we're getting close to 1 o'clock. This is a good time to break, I think. Could we take our lunch break?
Yes, sir, we'll do that. What I propose, if this doesn't create too much of a hardship, is that we take a 1-hour lunch recess today. So we'll resume at 2 o'clock. It's a few minutes before 1 now, so we'll resume at 2 o'clock.